All right. How we doing, everybody? Good to see you all. Good to see you all. What are we looking at tonight? We're looking at Sarah Boone's latest August 5th case management hearing, and it has risen some serious concerns for me, guys. I'm not exactly sure what the hell is going on. I don't think that the court or the state are doing good. Trying to figure out this whole process. What is the end game here? You know, we have to remember that the court hears loads of cases. This is just another case to the court. You know, the judge hasn't been sat there for 5 years looking at her interrogation video going, what the hell is this? Like all of us. The prosecutor's been real busy. Major concerns I have about the prosecutor. I've got a little comparison video to a certain councilman out of Rhode Island, and I think we might be seeing some signs, some dangerous signs. So we'll be showing you that as well. I just started watching The Last Seduction with Linda Fiorentino, which some of you may remember I've been suggesting as a movie that contains a character played by Linda Fiorentino that I can no doubt imagine Wendy Adelson watching this movie in 1994, a classic era of American cinema, and looking at the character and thinking, yes, this is me. This is how I operate. This is what I want to do with my life. She's a total sociopath. Great movie. And I couldn't really remember the story when I was suggesting it to people. But it's not really a movie that reminds me of Wendy because she's doing exactly Wendy things like we know in the story of Dan Markel, but just the character, how she operates, how she walks around. I can just imagine, you know, when you see a movie and you think a character reminds you of yourself, but you know it's just a fantasy. It's like that. And I'd forgotten all along that the character's name in the film is Wendy. She's got this thing about writing backwards, writing the letters backwards. So when she leaves a note for Bill Pullman, he has to hold it up to a mirror. So she calls herself Wendy Croy. Croy being York backwards. The first three letters of Wendy are W-E-N. Backwards is New. New York backwards is Wendy Croy, which is how Bill Pullman figures out where she is. Everybody should go watch The Last Seduction. I'm only 20 minutes in. It's been 15 years since I've seen the movie, but it's fantastic already. So good, so good, so good. Great soundtrack, great everything. And Linda Fiorentino is awesome. Anyway, guys, back to business. Back to business. Where are we? Where are we? We're going to be sharing this tab now, huh? Ready for that? Present. Share screen. I'm guessing a lot of you have seen this video already. I was a bit late to the party. I only saw it yesterday. And yeah, I thought we'd just watch it together and pick out a few things that we see and try and work out what is going on. What is the end game for the court or the prosecution? We know what Sarah's end game is. Walking out of jail. And I can see pretty clear steps that would allow her to do that. Where are we? Where are we? Here we go. Welcome to everyone in the chat, and thank you so much for all you new members to the channel. We've had a swarm of members coming to join the YouTube membership, the Buy Me a Coffee membership, and all the rest of it. So thank you. Welcome. Isn't it funny how Sarah can, just by sitting in a chair, barely moving, have this loud attitude? Doesn't she just emit this hostility, this vibe? What a vibe, man. How annoying it would be not to be able to scratch your nose, huh? You got that belt on, your handcuffs are tied to your belt. Ugh, how annoying. That would annoy me no end. Yeah, Christina, it may be because of medication that she's on in the jail, but you know, when you've been a chronic alcoholic for as long as Sarah has, even when you stop drinking, this effect that it's had on your overall metabolism stays with you and continues to deteriorate the collagen in your skin and everything like that. It's never going away, especially much more so in women for some reason. But I'm not a doctor, but I have seen one on TV. Hey, Kaza T, back again. How good to see you. I haven't seen you in a while, Kaza. How you doing? Man, God, look at that. Look at that prison secure pen. Doesn't it have a weird tip? Man, I really like a good pen. You know, I appreciate a rollerball. What is going on? Fancy Fiction. Oh, we got a message from Fancy Fiction. Okay. Hi, Fancy. Are you in the chat? I quite like this cameraman. I'm always looking. I used to be a cameraman, so I'm always looking at their compositions. it's he's quite good. And what a subject, Sarah Boone. Hi, Ryan. Angel baby, hello.
Ms. Boone, raise your right hand to be sworn, please. Please swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Ma'am, good morning. Could you please state your full name and date of birth for the record for me?
Sarah Boone, 10777.
I do see that we have a representative from JACS that's appearing virtually. Sir, can I get you appearance for the record as well?
How's the audio, guys? Is it good levels? I mean, Sarah Boone's not got a microphone, so we have to make do with what we can, but the judge is mic'd up. Yeah, let me know how the audio is, guys.
Yes, Your Honor. Christian Lake with the Justice Administrative Commission.
Okay, very good. All right, we've got a couple of things that we're going to be addressing this morning. The first is the motions, Ms. Boone, that you had made reference the last time I saw you. The court has reviewed all of those motions. I've reviewed also JACS's reply, specifically their response to the motion seeking due process costs that was filed on July 30, 2024. State, have you had the opportunity to review all of Ms. Boone's motions?
Yes, Your Honor.
Okay, all right. Ma'am, I want to go through each one of them and hear from the state, from yourself, and from JACS. We're going to start first with y'all can be seated, you don't need to stand, thank you. The defendant's temporary motion for reservation of proposed cost to acquire Investigator for defendant's defense and trial dated July 18, 2024, received July 29th. That request seeks to reserve any and all costs proposed to be incurred to acquire Investigator. The defendant's temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense and trial dated July 18, 24, received July 29th, 2024. The request is to reserve any and all costs proposed to be incurred to acquire all witnesses for trial. And then defendant's temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court dated July 18, 2024, and received July 29, 2024. I have reviewed all of those motions. All three motions reflect to be determined or TBD with regard to the investigator, witnesses, and deponents. The total amounts are to be determined. How to calculate is unknown. As to the depositions, the date are to be determined, and the amount of transcripts are unknown. Mr. Lake, I've reviewed your response. Do you have anything else to add, sir, with regard to those items, investigators, witnesses, or deponents?
Not really, Your Honor. The only thing is we can provide Ms. Boone a copy of our pro se packet that has information about, including model.
And this guy spells out state worker, doesn't he? I work for the state. Yeah, we know.
Motions. We would be happy to send her a copy or to send your JA a copy that you could send to give to her. That might help her for purposes of future motions. But as far as these are concerned, I think our response pretty much outlines what our position was to each of those requests.
Okay, thank you, sir. If you would be so kind to send that to Ms. Barrios, we will ensure that Ms. Boone gets a copy of it. State, do you have any position with regard to those three motions that the court just identified?
No, Your Honor.
Okay. All right, ma'am. So previously, Prison Break Investigations was already appointed to be your investigator. The JAC has no objection to authorizing $5,000 in costs for Prison Break and for $500 for obtaining case-related documents and materials on your behalf. So seeing as there's no objection, even though you were asking for a reservation, I'm going to go ahead and permit that cost to be incurred. With regard to the costs for witnesses and the depositions, you are requesting, as I identified earlier, just to reserve those costs. And as I had said earlier, the motions do not identify who the witnesses are or what the deponents are. So I'm going to deny those motions with prejudice, but that means you can refile them and we can readdress them when you file motions in the future addressing any of those items for ensuring witnesses being subpoenaed or appearing for your defense at trial, or for any persons that you may seek to depose. Because as of right now, I don't know who it is that you were seeking to depose based on your own motions. Do you understand?
I don't think Sarah knows who she's seeking to depose. Who is she going to depose? Imagine having to take all this in without any training when it's your own life on the line. That is a tall order, and one that really concerns me when it comes to giving her grounds for appeal. We'll get to more of that soon, guys. There's good grounds here for her appeal. And I think if the trial goes how it looks like it's going to go, appellate lawyers will be lining up to take the case. What do you call it? Is it pro bono? No. Like, what do you call it? When they take a percentage of the compensation. They say, yeah, we'll take 50% of whatever you get.
The court's ruling as to those three motions, and do you have any questions, or do you want to add anything?
I would like to add, please.
Sure.
With your delegated due date of July 22nd, for all of my pretrial motions to be submitted, I have yet to receive my discovery, so I was trying to beat that deadline or at least meet it. So I don't know what I'm supposed to ask for or who I'm supposed to ask for. And again, I have yet to receive my discovery, so I don't even know who it is I need. So I understand for those. So you're telling me at a later date, once I have that information, to revise them.
I'm giving you the opportunity to refile. Yes, ma'am.
Thank you.
With regard to the defendant's motion for reservation of proposed costs With regard to defendant's motion for reservation of proposed costs to acquire expert witnesses for the defendant's defense in trial dated July 18th, 2024, and received July 29th, 2024. Mr. Lake, anything else to add other than what is identified in your response?
No, Your Honor. Again, the issue here is with the exception of the mental health expert that's already been approved.
So we've got a Mr. Lake and a Mr. Lane. Okay.
There would need to be
Lake Lane. He's got a cottage on Lake Lane.
much more specific motions for these costs. Ms. Boone needs to include essentially what we included in our response. And again, the model motions that we will be sending to will have that information. Without specific information, neither us nor the court can make an informed decision on whether the requests are appropriate.
Okay. Ma'am, the motion fails to identify any specifics. It has to be determined for your expert witness or witnesses. It does not identify the type of the witnesses. It doesn't identify the amounts, and it's difficult for me to identify the particular showing of need, which is what's required for the appointment of that expert. So again, I'm going to give you the opportunity to refile in the future a motion pertaining to any specific experts, identifying the specificity that JACS has requested in their response. So at this point in time, that motion is denied without prejudice, and you'll have the opportunity to refile it. Lastly is the defendant's motion requesting immediate relief to the defendant by appointing effective standby counsel to aid in support and preparation of a criminal case for trial dated July 18, 2024, and received July 29th, 2024.
You see, Sarah has completely misunderstood what having standby counsel means. The judge is going to explain that a little later, but I think what Sarah thinks it means is that she's got a counsel standing by, on alert. You know, she can call him up anytime. They're standing by. No, that's not what it is. It's not even having a lawyer. It's when you're representing yourself and you have standby counsel, if you get to a point where you feel that you don't want to represent yourself anymore, you can elect to have standby counsel take over and start representing you, and you will just be sitting in a chair. It's not a lawyer like having one on hand. You can't ask questions. You can't send information. It's just like a backup if you want to pull the plug. But it's an interesting case because Sarah hasn't chosen to go pro se. She wants to defer to standby counsel immediately, and the trial hasn't even begun. It's a really strange, unusual situation, and one that I don't know if the court is handling well and safeguarding the importance of their conviction. And the court may not care. The court may just want to get through this process however way it lands. But remember, Jorge Torres had a family. And what is their opinion of all this? Surely they want to see her in retribution, paying some retribution by doing the rest of her life in jail, right? So I think their needs should be taken into account primarily.
Request, ma'am, that you were seeking in that motion is to provide immediate relief to defendant by appointing effective standby counsel to aid in support and preparation of her criminal case for trial.
Yeah, she wants it to aid in support and preparation for criminal case of her trial. That's not what it is, Sarah. You've got it wrong, Sarah.
State, do you have any position with regard to Ms. Boone's request for standby counsel?
No, Your Honor, other than what's already been placed on the record in the court's order.
Okay. Mr. Lake, anything over and above what's in your response?
Just briefly, Your Honor, the point we would make, Your Honor, is I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when in the situation where a pro se defendant who is elected to represent herself decide at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is decided to represent themselves decides at some point they do no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is incenting not to get involved until the defendant says, I no longer.
Neeti says that she has no idea what the court is supposed to do with her. Well, I think the court should just say, okay, you want a lawyer? What lawyer do you want? We'll pay the bill. We'll get you any lawyer in America. Tell us the lawyer you want, and it's covered, paid for by the state. Now, see you at trial and be ready. That would be the easiest way to safeguard against her appeal, right? And she would have no cause for complaint. If she fucked that up as well and alienated lawyer number 9, and lawyer number 9 came to the judge and says, please let me out of this, I can't stand this, I can't stand this, I can't talk to this woman anymore, then she has to represent herself. But I don't know why the court has not done that. It does happen in Florida. I don't exactly know what the requirements are, but it's a thing that happens. The court will pay for private counsel. Her big issue is that her lawyers have other cases. If you're a court appointed counsel, maybe you've got 10 cases at one time. You have to be doing work for other clients. You can't be available on the phone 27, but a paid lawyer can, the agreement is between the lawyer and the client. Whatever that agreement is set. So she says, okay, the court, you pay for my lawyer that's going to be with me 100% of the time. It's only a couple of months down the road. It's not going to cost, maybe it'd cost, I don't know, 80 grand, 100 grand. It's not that much. This trial is going to cost the state a lot of money anyway. It's not that much of an increase. That's what I think the court should have done.
Want to represent myself.
Ma'am, the court's had the opportunity to review the case law on this issue. There is no constitutional right to stand by counsel as decided by Paul versus State, 152 Southern 3rd, 635 at pinpoint 640.
Oh, I'd love to know more about Paul versus State. Maybe we should look that up another time.
Won by the Florida 4th District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State, 449 Southern 2nd, 253 at pinpoint 258 from 1984. As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel. That's Brown v. State, 45 Southern 3rd, 110 at pinpoint 114 through 115. Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se with legal representation by the Florida Supreme Court in 2009 in Shepard v. State, 17 Southern 3rd, 275 and 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied.
He really loves going on about this 16-page order. I think it's the longest order he's ever written, because every chance he gets, he's like, yeah, the 16-page order. Oh.
Do you have any other questions, ma'am, as to the court's rulings this morning?
First off, I do not forfeit my rights. That was your judgment. And also, I feel that I should have had some type of evidentiary hearing prior to your decision. So I could have better explained myself and you could have had a better understanding. So by you denying my standby counsel, which thank you to him for explaining to me what specifically it is, I don't want to be pro se any longer. So I didn't want to be pro se in the first place. And again, you, in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy to even understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity, or if it's just something that is denied, period.
It is denied, period.
Thank you.
With regard to an evidentiary hearing, that seems to be in the realm of a Ferretta inquiry where a criminal defendant is seeking to represent themselves. And I would inquire of that person and have an evidentiary hearing as to the rights and remedies that you were forfeiting and the pros and cons of proceeding representing yourself and the benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order, no such evidentiary hearing is required.
My understanding was the hearing, the Ferretta hearing, is regards to competency as opposed to.
I know, Niti, right? First off, before I steamroll into the court here and attack the judge personally for his ethics, for his lack of ethics, first off, she's something else, you know.
Having an understanding before you take someone's right away.
Ferretta pertains to a criminal defendant's seeking to represent themselves. Ferretta was not applicable to your situation, and that's identified in the case law citations that were provided in the 16-page order.
Yes, I understand. It was the day of that I was explaining most of all of this, and as opposed to prior, so I would know what would happen or could happen. So my understanding is one thing, and then the explanation is another. So I'm just.
Yeah, my understanding is one thing, and then the explanation it's another thing. Yeah, Sarah, that's called being wrong. Okay, just clearing that up for you.
Confused and feel that I should have had an opportunity prior to all of this to explain myself and to have a better understanding. So now my belief was that the evidence or the Ferretta.
You know, she's taking the opportunity here. There's a court stenographer writing everything she says down. It's all on record. She's taking the opportunity to put all of these grievances on the books. Any appellate attorney can refer to this and, you know, certainly have grounds to appeal against the handling of the case. Whether or not that would be founded is a different story. But in Charlie Adelson's case, for example, there's no grounds for appeal. He loves Daniel Rashbaum. He admits that the judge was perfect. His only hope is that a juror did something like, I don't know, investigate the case when they shouldn't, stuff like that. That's his only hope, which isn't likely, right? Sarah has grounds. All of this is going on record.
The hearing was simply competency. So the evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my rights counsel. That, in my opinion, I felt that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the intervention of the judge and or the court to avoid any of this.
That is a huge, earth-shattering accusation she's just made, that the court acted in retaliation to her, right? I'm sure the court has acted within the confines of the law, and if any court was found to have retaliated and made some kind of emotional decision, yeah, Nat, you wrote a letter, you wrote 5 motions, here you go, look at you now, no counsel. Yeah, that court would be in trouble, right? But that's obviously not happened.
Sitting in front of you present.
Ma'am, as identified in my 16-page order, I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promised you, I've read everything in the court file. I've read every single letter, and I've listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision, which explains why it was also a 16-page order. That order stands, it remains. The court's not going to revise its findings or its determination as to your forfeiture, and alternatively a waiver by virtue of the conduct identified in that order.
Okay, I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the attorneys. And by you reading and then also listening to the audio, you did not listen to me in any way, shape, or form in order for me to explain myself better, so you have an exact understanding of the particulars of each letter for each attorney.
I'm not going to revisit my prior decision.
I understand. I'm just trying to make you aware that is my opinion.
You, and like we talked about last time, and you're certainly entitled to that opinion.
I love the way this judge says, yeah, you're suddenly entitled to your opinion. We're moving on. In other words, shut up.
All right. My judicial assistant has been in contact with the representative from the Orange County Jail, Sergeant Donald Casey, who is on his way in order to facilitate the transfer of the USB drives from Prison Break Investigations. I do see that Mr. Lane is present. So as soon as he gets here, we'll be able to address that exchange. What we can do while we're waiting for that representative to appear is address some of the things that were identified in the notice of hearing for today, which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks. So the trial will take place on October 7th, October 14th, and the third week of October.
A 3-week trial. That's long. That's a long trial. Charlie Adelson was done in a week. 8 days.
October 21st. October 21st is not this division's normal trial week. However, the court has obtained coverage for that week so that should this trial proceed into a third week, we will not have to scramble in order to find coverage, and that we'll be able to efficiently proceed with any evidence or testimony on that third week on October 21. Pre-trial was scheduled for September 24th at 1:30. The court typically has its regular trial case managements on that Tuesday. Due to Ms. Boone representing herself and some of the complex issues that may be involved in this case, I'm inclined to change the date of the pretrial so that we might be able to have our own pretrial separate and apart from all the other cases that may be set for that same trial period. My thought would be to move it to, rather than the Tuesday the 24th, to Tuesday the...
Hey, Clarissa H., how you doing? And all our other fantastic YouTube members, thanks so much for supporting the channel, guys. Means the world.
26th at 9 a.m.
Is that a Thursday?
Yes, sir. That's Thursday.
That's acceptable to the state.
Ms. Boone, that would give you additional opportunity to prepare for trial as well. Are you amenable to changing that date to September 26th at 9 a.m.?
So an additional 2 days?
Correct. You would still have that time to prepare regardless if we had the hearing on September 24 or September 26th. I'm just moving it so that we don't have 50 or 60 other cases and I can focus more attention on your case specifically.
50 or 60 other cases. What, in a day? That's nuts.
Of course.
Okay, all right. So pretrial will be rescheduled till September 26th at 9 a.m. One of the issues that I wanted to address was deadlines for production of the state's exhibits and the defendant's exhibits. Now, I'm mindful, Ms. Boone, that you have not reviewed some of the documents that may have been provided. I know most recently, Ms. Cashman spent 20 hours with you alone going over questionings and reviewing some of the materials. I don't know the breadth and scope of what was reviewed to you, but some of it may have been reviewed to you based on counsel's representations. State, I want to address with you first, because Ms. Boone hasn't reviewed the discovery yet, as to what your position is with regard to assembling or finalizing an exhibit list or your exhibits for trial.
As far as providing a list of the specific items that.
Okay, you ready for this, Mr. Cacciatore, Dave Cacciatore is wearing a lengthy raincoat, okay, in court, and just check out his delivery. This guy is on something, okay? I have always, from the very beginning, the first time I saw him, I was like, this is the guy that they've put in this case? He seems not to have much confidence or prose or stamina, just doesn't really, I mean, he just seems really vacant. I don't know why. Look at this delivery.
The state seeks entry.
Correct. I do want it before pretrial. So let me just kind of lay the map for what the court's thinking. The court would have the state provide a exhibit list and a witness list by X date. Ms. Boone would have the opportunity to look at that list. We would then have a hearing where all of the exhibits would be shown to and provided to Ms. Boone. They would be provided on a USB thumb drive that could be utilized with a laptop at the jail. And then she could view all those exhibits here in open court. And then she would be afforded the opportunity to make an objections in writing to any exhibits at a later time by a certain date.
I mean, I understand why he has to describe and explain everything about the procedures to Sarah like he's talking to a 3-year-old, but why is the judge having to explain this to the lead prosecutor on the case? This is standard procedure. This happens in every trial. Is it his first day or what? I just don't get it.
I guess one of the concerns would be that if the state identified specific items that we would seek entry of, depending on the course of the trial and the questioning, there may be other items that have already been disclosed in discovery that may necessitate being entered in, would potentially not be part of this original witness exhibit list. Items that were in the discovery, but if that makes sense.
That does make sense. Yeah. And I understand what you're saying. And that seems to be more of a fluid situation as to what may happen at trial, right?
Sure. I don't imagine the court's intent would be for the state to just produce the exact witness lists that have already been sent in discovery and just make a notation of every item of evidence. The idea would be to try.
Yeah, right, Neety. That is a flasher's coat, right? He's going to flash the jury.
Pare down.
That's exactly the idea. Now, obviously, that wouldn't foreclose you if something was produced in discovery and something that would not be relevant or admissible at a certain stage of the
hands in your pockets. Take your hands out of your pockets when you're wearing that raincoat, please. and don't put your hands in the pockets when the judge is talking to you. Is that a good look? I would know not to do that. That's no good.
trial, but maybe later became relevant or admissible due to something that happened or something that was said, I would not foreclose the state, nor would I foreclose Ms. Boone from attempting to move that piece of evidence into evidence for the jury to consider. But it would be almost like a civil conference where you and opposing counsel would go over what your exhibits are prior to proceeding to trial. And I think that's important to do that so that Ms. Boone has the opportunity to view those in court so that's on the record as to what she's reviewed, and then give her the opportunity to provide any objections, if any, to any of those exhibits. And again, I wouldn't foreclose you if you want to use items A, B, and C, and that's all you intend on using. I don't know what you intend on using. I don't know what evidence you have. If you only want to use and only show A, B, and C, but are saving D, E, and F for later, depending on what happens, I won't foreclose you from readdressing D, E, and F. But it's just an opportunity to address what it is you think you're going to be seeking into evidence at this time.
So essentially,
now his boss has had to step in and say, listen, you're blowing this. What did we talk about in the car? Take your fucking hands out of your pockets, man.
Go ahead, sir.
so I think we could accommodate that if we could go around September the 1st for that, and then that would give her an opportunity to review that USB and lodge any objections, and then we could potentially address those objections. And
Man, you know how I'm always going on about Christopher DeCoste being a born salesman. Everything he does, his speech, his intonations, his delivery. This guy's like the antithesis of that. So basically, September 4th, we will meet with the defendant to discuss the pretrial hearing.
go from there.
Okay. And that would be September 1 to have the evidence viewing, for lack of a better word, or for the list to be provided?
For the list in the USB.
The boss has stood next to him. I think we've all had our boss stand behind us at some point or another, right? Ready to pick up all the pieces that you've dropped. It's never good when your boss is standing that close.
Yeah, we're going to make this work for an October 7th trial date, Judge. I think September 1st is probably about the right time frame to have this in-court hearing.
Oh, look, a bit of fluidity.
To begin lodging those objections if she has any. My next question is, are you expecting the physical evidence to be brought here into court by a CSI so that she can potentially open it? Or are we just talking about digital evidence and giving her a list of the physical items?
If there's physical evidence that's sought, I want her to have the opportunity to review it.
And we should be looking at the top of the month for September so that we can get this done.
Okay, all right. Ma'am, do you understand that what it is that I'm discussing right now, so that you have the opportunity to review the evidence that the state may be seeking into evidence in your trial?
Is it my understanding that they will supply me with a USB drive and then I am to review it while in court?
No, ma'am. So it's kind of a two-step process. So anything that's digital, that's not forensics or CSI or something that's tangible, will be provided to you on a USB drive. We also will have a hearing where all of the evidence, including any digital, electronic evidence, or any tangible evidence, CSI materials, will be shown to you in court, played to you in court, so you have the opportunity to review it here as well. Anything else will also be given to you on a thumb drive for you to review at your leisure based on the hours of 8 to 4 by the laptop at the Orange County Jail. And then we will have a deadline after we have this evidence viewing for you to identify in writing any objections that you have to any of the evidence that's been provided by the state.
So it's not a matter of any type of confidentiality, it is all done in the courtroom with everyone?
It would be in the courtroom, correct?
Are there going to be news cameras and photographers?
That's something I need to address. I do not want, because our jury pool is going to be coming from Orange County, I have concerns about media's presence in the evidentiary viewing. So I may have to enter an order which would prohibit media access for the purposes of that hearing due to the nature of what is being produced and reviewed, so as to further prevent intimate details of the case being released prior to trying the case.
I understand that, Judge. Ms. Boone, not to turn the page completely, but I think it's pertinent to this discussion, has indicated through some counsel that had met with her recently that she wants to talk to the state out of the jail. And I was going to discuss that at the end, but perhaps to not waste the court's time, I don't know about bringing physical evidence out to the jail, but as far as the digital evidence, which will include autopsy photographs, which will include crime scene photographs, which will include videos, perhaps a different suggestion, especially since she has an investigator from Prison Break, is that we identify those files that we intend on introducing at trial so that they can review that digital evidence on their own in the jail, and we're not publishing all the digital evidence here in open court. That should allow her the opportunity to lodge any potential objections such as duplicative or any other objections she may want to raise about autopsy photos, so on and so forth, without exposing all of the digital media to the public. As far as the physical evidence, the state doesn't have any real concerns about the media covering that. She can open those exhibits, or somebody with scissors can open those exhibits for her.
Again, the state doesn't have any concerns about the media covering that. The judge has just made clear the concerns. He's concerned that if the media covers her reviewing the physical evidence, which she's going to have to do in the courtroom because they can't send the physical evidence to the jail because they don't have a way to securely store it or provide it to her, Sarah's going to have to come back to court and look at it in the court. So she knows exactly what the state has to work with, has time to prepare, and can make objections if she doesn't think a certain piece of evidence should come in. She's going to do it in the court. The judge has said he doesn't want the media there because if the media are there, they might see some of the evidence, and as the jury pool is coming from Orange County where they are, if they were to see what the evidence is, they might have prejudice against, know something about the case before they come in, right? And the state has just said, yeah, we don't mind. Again, if that happened, more grounds for appeal.
Or any exhibit she wishes open in the witness box where it's concealed from the media's eyes. So those are my suggestions. And then later we can turn to her request and put on the record how we would go about going out to the jail and meeting her.
The only concern that I have with that is I don't have a record as to what it is that she reviewed.
My suggestion would be that because this is in the context of plea negotiations potentially, I would be out there, Mr. Cacciatore would be out there, and our investigator would be out there, and we would record it. The conversation that we have, of course, and that would all be protected because it would be in the spirit of plea negotiations under the evidence code. And then we can all file in writing, the state can file in writing, these are the videos that we are going to use. These are the particular photograph numbers from the crime scene and from the autopsy photographs that we're going to use. And then we can have the defendant sign off on that as well, so that it's documented as to what was told that she would be facing at trial. And either she can review it with her investigator or she can review it with us, being present, and then that way the digital evidence is now in the open.
Okay. Ms. Boone, what are your thoughts on that?
I'm a little lost.
I'm a little lost. Yeah, I was just thinking, I mean, I actually don't think she does too badly. I mean, it's terrible, of course, but put yourself in that position, having to come up with a worthy question just right off the bat, right off the cuff, just, it would not be easy, especially when it's your own life on the line. Your emotional investment, when a lawyer is doing these procedures for their client, they're able to separate themselves from the stress of the consequences, right? This is why you shouldn't represent yourself. That saying, what is the saying? He who represents himself has a fool for a client. because you shouldn't do it. And Sarah's being forced to do it. And maybe this was her plan all along, right? I don't think that I think that. Maybe. But is she that forward thinking, like going, yes, what I'll do is just bitch and moan at every lawyer until they want to put their own finger into their eyeball and they withdraw from the case, and then they'll be forced to let me go. I don't know that she can think that far ahead myself. I think she just genuinely wanted someone to do everything she said and wouldn't accept any. These lawyers were probably saying, listen, the case as you see it is a bad idea. It's a really bad idea. It's not going to work. We need to do it like this. In all of my law experience and study, we need to do it like this. And Sarah's like, no. I was an abused spouse. But yeah, she doesn't do too badly in coming up with questions in these conversations with the judge in this incredibly high pressure scenario.
Of reviewing what the state has with my investigator and then be able to come with the objections and everything.
That is correct.
I'm unclear on having all of my evidence being in sealed bags and for me to be able to inspect them to be here in the courtroom. I don't know how the attorneys have done any of this prior, but I don't believe that it was in the courtroom. So I'm just trying to protect myself against the media. I'm not sure at this point.
I don't know what her big thing is about the media. I don't know what the law is in Florida, but this is why we watch so many cases out of Florida, because they really seem to have the cameras in every friggin' trial, don't they? It's different state to state, but Florida love it. There's a name for it's called the open, I don't know, I can't remember. Anyone know?
What is even suppressible that is available on the internet. But at the same time, though, it is my understanding that I should have some right to privacy in reviewing the evidence. So I didn't know if my investigator and I are able to collaborate prior and view and then come to court with everything finalized and ready to go with answers.
I'm certainly going to give you an opportunity to meet with your investigator to address it. The question is just the method of how to do it. The state's proposal is digital. They would meet with you, identify specifically digitally what videos, what photographs they intend on utilizing, and anything that may be physical, CSI, et cetera, would be addressed here in open court.
Just so the court and the defendant understands how physical evidence viewing would operate normally, the defense attorney and or her or his investigator would come out either to the sheriff's office or OPD's evidence center, whichever agency, and they come and view it. But it's done in the presence of the state, it's done in presence of law enforcement, it's done in presence of the CSI for the chain of custody. So attorneys don't get privacy when they're reviewing the physical evidence either. So that wouldn't really be any different than if she's doing it in the witness stand or wherever you deem suitable in the courtroom.
I think that's the most appropriate way to have the opportunity, ma'am, to review the evidence. I can't release that evidence to Mr. Lane to bring to the jail for your review because of the chain of custody issues concerning some of the physical evidence. So CSI would have to be here just like an evidence viewing at the sheriff's office or elsewhere where counsel just identified. And I cannot bring you anywhere else other than here, and I can't release you to anywhere else. So I think the only solution that we have is to have the evidence viewing here with regard to any of the physical evidence.
Why is it that it can't be transported anywhere other than here?
Sunshine law. Yeah, I think that's it, right, Rabbit?
Because I cannot make a record anywhere else of what you saw or what was reviewed. The only opportunity for me to make that record is here in court.
What did prior attorneys do?
That was already identified by the state.
I know I'm trying to keep up with everything. What was the answer, please?
So an attorney who's doing an evidence view would come out to the law enforcement agency's evidence warehouse, for lack of a better term. And then in the presence of the state attorney, the CSI, and the lead detective, they look at the package, and if they deem any particular package worthy of opening and examining, they can do that. We can have the CSI bring a butcher paper here so that any particular item can be opened. But
Butcher paper. Fantastic. It's okay, Sarah. We've safeguarded your constitutional rights. There will be butcher paper at your evidence hearing. Okay.
on fresh butcher paper and then changed out between exhibits so that there's no contamination. And then you can examine it. If Mr. Lane or any other representative from his organization is here, he will have the opportunity to photograph those exhibits once taken out of the packages. And that's essentially how an evidence viewing is conducted.
Thank you.
You're welcome.
And again, please, would the media be involved in that?
That's a conversation that I need to see if I can exclude them from participation or viewing that proceeding. There are rights where the media has to view proceedings in court, but due to the sensitive nature of what may be being discussed or viewed, I need to see if I can prevent media access. So without doing a little bit more further dive or research in that, I don't know if I can make that call at this time.
Yes, I have not heard of a case where the evidentiary hearing has been televised. So, if you could please look into that, because I disagree with the media being involved in that.
I understand your position, and again, for the reasons that I stated earlier, I'm trying to prohibit as much as I can.
Yeah, he said that he's going to look into it.
And from dissemination to the public, especially some of the exhibits that the state may be seeking to utilize. We are going to go ahead and set the evidence hearing. The first is Sunday. September the 1st is a Sunday, and that is Labor Day. The court would be setting a hearing for Tuesday, the 3rd at 9 a.m. to have the physical examination here in court. At that time, in the USB drive or the after our viewing here in court, state, is it your position to then have that?
And this judge is just hearing the scotch pour over the ice cubes right now, isn't he? Like he's like, get me out of this room. Not only have I got to deal with Sarah Boone, but the prosecutor's on drugs and everything is just like pulling teeth out of a sheep's mouth.
Meeting with Ms. Boone and her investigator and your investigator under the plea negotiations or settlement discussions auspices to review all of the digital and identify what it is specifically.
We are happy to defer to the defendant's wishes on that. And I wanted to have that discussion. It seems like we're turning that discussion. So I'll leave it in Ms. Boone's court. My indication from one of the attorneys that she had discussed things with said that she wanted to have a conversation with us. And so I'm offering that up. In the past, with female defendants at the Orange County Jail, there are classrooms, at least one classroom there, where we could arrange to meet. It would be a big enough room for 4 or 5 of us that would need to be there. And then we can discuss that, whatever it is she wants to discuss, and it would be recorded. And again, those portions of the conversation that are about plea negotiations and the evidence and whatnot in the trial, I believe under the evidence code would not be admissible to be used against her.
Plea negotiations. You see, this is what I think it's all about. I don't think the state want to try this case. I think they want a plea deal, right? Sarah doesn't want a plea deal. But she was offered, wasn't she offered 10 years for manslaughter? And she said no. She's already done 5. I mean, if I was her, you know, you're already in prison. You're already in jail. You do another 5 years. You've done 5. It's like once you're halfway, you can go, okay, we just need to do that again, and then it's done. It gets better. It goes quicker over when you get past that halfway point. So is the state like making all of this tsunami of pressure that they're putting on Sarah? Is it to force her hand and say, okay, I better take a plea deal, because what am I going to bet all my eggs that I win my appeal if I get convicted? There's no way that she's going to be able to effectively represent herself in court against even this drug addict prosecutor that we saw a moment ago with the raincoat. You know, there's no way that a jury is going to side with her, sympathize with her, or take anything she says seriously in terms of what happens with the suitcase and George and everything like that, right? I mean, maybe we won't even see a trial. Yes, Leah, I saw your message earlier. It is set for October 7th currently, but maybe it won't even happen. Maybe they'll just put all this pressure on her, keep piling it on, say, listen, you do another 5 years and you're done. But my question is, how did George's family feel about that? She'll be out before she's, well, she'll be just over 50, 51, 52. So, you know, she'll have a second chapter of her life that George hasn't got. He's in the ground, right? George's family should be in this room with Sarah Boone and seeing what's going on. I'd love to hear something from them. I guess if there is a trial, many of them will be called as witnesses. It's quite a big family, I think. He's got brothers, cousins, mom and dad. Yeah. But is this the state's angle? Does anyone think that the state is just pushing for a plea deal? Say, listen, you do another 5 years and you're done. Or you want to go to trial?
I can leave it to her when she wants that.
Okay, we're about an hour into the video, guys. If you are enjoying this video and you're still here, thank you. We love you. Please leave a like on the video, subscribe to the channel, and ring that bell so you get notifications when we go live. If anyone would like to support the channel, there's links in the descriptions to buymeacoffee.com, where you can buy us a coffee.com. It's got a real good way to support the channel on there, guys. Also, Patreon, YouTube memberships, buy me a coffee memberships. There's 3 platforms where you can become a True Crime Metrics member, which is a fantastic way to support the channel, help us grow, help us continue to grow. I mean, we've been growing so quickly. We've got about another 4 subscribers to go to 1,400. It was only a month ago that we crossed 1,000. Less than a month. It was July 10th. We've done another 400 more. Wow. Thank you so much, guys. Thank you for the support, recognition. We hope you're enjoying the ride as much as we are. Subscribe, like, support the channel. Oh, and also on YouTube, super chat, super stickers, super thanks if you're watching on demand, right? Fantastic ways to support the channel. We love you all. And let's continue to enjoy this video. Or should we go to the drug addicts? Let's have a look at this guy. Let's change it up a bit, guys. Just chop and change. Okay. So this is a councilman out of Rhode Island. And when I've come to the conclusion that this prosecutor for Sarah Boone must be on drugs, there's just no way that I can imagine he's not on drugs. The guy that stepped in for him now and is speaking to the judge, his boss, it looks like, he's not on drugs. You can tell he's not on drugs. But this guy and Mr. Cacciatore seem like they're on drugs to me. And this guy here is a councilman. He's just ended his entire career. This is a body cam. Thank you so much, Neeti, you little diamond, for the super sticker. Thank you. Yeah, this guy has just ended his entire career. Basically, he's doing crack. He's smoking crack in the court parking lot with the door open, or maybe the cop opened the door actually, but he was convulsing and coughing and all sorts of stuff, unconscious, and some person walking by thought he was having a heart attack, ran out into the road where he saw a black and white coming down, a cop car, and stopped the cop car, and the cop is now coming into this guy's car to investigate what's going on. He pulls out his ID and he sees the badge for the councilman office, and he goes, "Oh man, no way, you've just ended your career." It's quite funny and sad, and funny and sad. There's no audio yet. Man, what a way to wake up. He even looks a bit like Mr. Sorry.
Oh, he's gonna pat you down. Yes, sir. Wait, interlock your fingers. Interlock your fingers. Do you have any weapons on you?
No, not at all.
All right.
Roads open, Boston.
You're gonna stop. Try not to. Oh, no way, dude. Really?
Yes, yes. I was just on my way back from court.
Bro.
I was just on my way back from court. Pretty nice suit.
Well, Orestes gonna come check you out, man. I can't let you go. You were literally choking in your sleep. Somebody flagged me down about it.
Oh, I have sleep apnea. I'm sorry.
Well, and then you have a crack pipe.
Yeah, he has sleep apnea, guys. Problem solved. Be on your way.
Yeah, so it's like,
Wait, sorry.
listen, I have a body camera. Obviously,
Yeah,
everything
obviously.
I have is recorded. You know that, and what I've observed is on camera, so I can't pretend I didn't. You know, so Orestes gonna come here,
Oh,
and
Jesus.
they're gonna check you out. You know, as far as I know, there's no drugs anywhere, so I
No.
can't. You know, so there's not a criminal investigation. There's more health or well.
Yeah, as far as I know, that I haven't looked in the car. There's a big bag. There's $100 bag, big rock in a bag right there on the gear stick.
Being checked type
Thank
thing.
you.
But yeah, I obviously have to document it. You know, you can have that back.
Thank you. There will be no arrest.
What?
There will be no arrest.
No.
There will be no arrest. Well, not until we find all the drugs.
Are there any drugs in the car or anything like that?
No, nothing.
All right. How long have you had this problem, man?
It was a relapse. I've been clean for 13 years.
All right.
Just went through a really, really bad divorce recently.
Okay.
Well, it can't have been any worse than Dan Markel's divorce, man. You didn't see him picking up the pipe.
Do you know if any of that was laced with fentanyl or anything? Because you were out, and like looked like you were choking.
Really?
Yeah. That's why somebody literally sprinted and flagged me down because they thought you were having a heart attack or choking.
No, not that I know of. Yeah, I was just carrying it on the way. I just.
Greg, I was on the second front handle is wrong for.
Sorry.
Sorry. Can you sit over towards the front of your car, please? Thank you. If you're unsteady on your feet, just find maybe one of those curves or something.
108. Can you 22 lobby for a civil complaint, please?
Careful.
Is Todd available?
And if you can't even wait to get out of the court parking lot where you do all your councilman things before you take a hit of your crack pipe, if you can't wait that long, you got a problem, man. Go home, man.
You want me to get him over here?
Would you mind?
Yeah, I don't mind. Just do me a favor. Can you come over to the front of mine? Thanks. Just hang out in the front while I make this phone call. Thanks.
Yeah, remember to keep those likes coming in. Like the video, guys. Really helps the channel out. Great way to help the channel.
So it's a little lower than only the blood pressure. I mean, we're not comfortable. I mean, obviously,
He wants to tell the cop me to.
no, the cop can stay here. I'm not getting in it.
No, we'll
Getting
stay
in
like that. We'll have him call someone at the station.
He can have. I mean, he wants to have his mother come get the car, but I'm not. I wouldn't have. No, I'm not getting in there touching all that.
He wants to have his mother come and get his crack fentanyl laced car. it's a hire car as well, guys. This guy has no one to call but his mother. His wife's left him, taken everything, and he doesn't even have a car. it's a bad month, man. Bad month.
All that.
Lost your job and you're an embarrassment to your career. And the only person you can get to come and pick up your crack and fentanyl laced car is your mother.
White powder, is that's a piece of crack. Yeah, that's definitely crack.
Yeah, most likely.
Yeah, you can smell it, and he's burning up.
He has a bunch of toy boy and.
Should we have a toad?
Looks like he's like half living out of his car. There's like toilet.
Oh, Amy, it's just because this guy is a councilman from Rhode Island that got caught smoking crack in the courthouse parking lot, and he's ended his entire career because he's got this problem. He said he's been clean 13 years and he's had a relapse because of a bad divorce. And it just reminded me of Mr. Cacciatore, because I'm convinced that the prosecutor for Sarah Boone, Mr. Cacciatore, is on something. His behavior in that courtroom was not right. And I don't put it down to just being nervous. He's a state prosecutor. You should know how to talk in court if you're a state prosecutor.
Property, we're good. We're on private property. And this guy,
Yeah, look at this. He's got a problem.
I'll do all the evidence stuff.
Thank you. All right, so is he rescue's good with him?
Yeah, they're just finishing up right now. He's got the grill and everything over there.
Yep.
Cell phone?
Yeah, it's right
Seize
here.
it.
Yeah, please.
Yes.
Oh yeah.
Yeah.
All right.
Yeah, Tracy, crack has a smell. It smells like ammonia, you know? It's that's what it is.
Yeah, I know. It's not like I have an option here, man. Sorry. Let me know if they're a little too tight or anything. They can loosen up.
Anything you can't turn anything? Nothing in there?
I mean, just water.
No, you got anything on you?
No,
Anything you can't turn anything?
I got gloves on. All right.
There's stuff all over that car. When your mother gets in that car, I bet she sits in that, touches her face or mouth and goes down.
I had no idea.
So, look,
No, I mean,
yeah, you don't know what you're buying.
Yeah.
Did you buy that today?
yes, sir.
Yesterday. And
Yeah.
you don't, is the same guy you usually buy it from?
they usually buy it off anybody. They're not all honest people.
No, I mean,
Once or twice.
yeah, but whoever you buy it from, if you continuously buy it from them, you know who you're buying it from. You don't know what people are putting in it.
No, I understand.
You know, they may have made that, but that's a big rock you got in there. What's that? A $50 piece?
100.
100.
Yeah,
So
I just got back into this.
So he got ripped off as well. He bought a $50 piece for $100. He has got no car. His wife's gone. He's ended his career. His mother can't come and pick up the car, and he got ripped off. Rough, man.
this is a terrible situation. We're all in a tough spot, but we gotta do what we gotta do right by the numbers. It'll help you in the end. Believe me when I tell you. And you'll say to us a month from now, good best thing that ever happened to me. That's what they all tell us. You can't go down this road anymore.
No.
God forbid we find you dead. That's terrible. You know what I mean? You were down in the car.
No, I have an appointment set up for the 17th to go get help.
Yeah. You gotta get on a program right away.
No,
I look at you. Yeah. You're not the Matt Riley that we know. Trust me. And listen. Your health and your well-being is worth way more than any political career.
I don't care.
We'll keep it. Listen, we're not. We don't report nothing to the media unless someone tells them. So then, arrest records are public record. I'm not gonna lie to you. But there's not much we can do on this. Unfortunately, if I was in your situation, I'd be in handcuffs.
No, I'm not saying. I'm not saying don't arrest.
Yeah.
In terms of media for kids, as much.
Listen. We are only required to release what we release, and we won't. We have to release an arrest record by law. All right, jump in before you. We just want to make sure we're gonna monitor you because you've taken in
I'm gonna pat you down again, all right?
You've taken in some fentanyl, Matt, and that's we've got to make sure you may not feel it right now, but God forbid something happens.
I think that's pretty much it, guys. But yeah, maybe the same thing will happen to Mr. Cacciatore. Should we get back to it? Back to business, guys. Leave a like on the video, share, leave a comment, and subscribe to the channel.
That to happen, we can make arrangements to try and accommodate that. It should not take us very long at this point, given the age of this case, to select and identify which digital evidence exhibits we're going to use. It's simply a matter of getting rid of duplicative and irrelevant photographs from the scene and the autopsy. And I believe the videos won't be too hard to decide which ones to use. I don't know that there's a whole lot of other digital evidence.
Okay. All right, ma'am, do you have a thought on when you would like this viewing to take place at one of the classrooms at the Orange County Jail under the
Good evening, Marcus. Good to see you.
concept as identified by the state?
So this meeting is separate. This is prior before everything else.
What I would envision, to not waste anybody's time, is we can go out there and have this discussion. If there is a discussion to be had about plea offers, one of the other topics was other matters, so that's kind of ambiguous. I'm not sure what other matters are. And then also we can let her know and probably provide the court in writing a list of the digital evidence that we seek to introduce. And then that way, if she wants us to review those digital evidence items together with her in the presence of everybody, we can do that. Or we can let her, with the list of the digital evidence that we plan on introducing, review that as many times as she wants by herself and or with Mr. Lane.
I understand. So would I be leaving with the digital evidence today, or how soon may I receive that?
So the state needs to assemble that. So my thought would be to have that meeting, ma'am, on the 3rd of September. So we would have a hearing at 9 o'clock in the morning.
You see, that's a way off as well. That's like another month. This is taking place on the 5th of August, and they're not going to give her evidence until the 3rd of September, and her trial is scheduled to start just a month after that. This is all looking like a shit show. I don't know why they've done it like this. I really don't.
Where the physical evidence would be reviewed here in the courtroom. As soon as that evidence was finalized and reviewed, the state with their investigator, yourself with your investigator.
Jennifer Pan from Toronto. Yeah, that's a good one, Neville. Good. And we get to see the OPP forensic psychology department do their thing again. That's always good. We haven't even done Russell Williams yet, but we'll get in there, guys. We're getting there. I don't know if we, it's difficult to find a place to slot in when we're all getting so excited for Donna's trial and then Sarah's. But we'll see what we can do. We'll see what we can do. Russell Williams, Jennifer Pan, and what's the other good one with the OPP is Michael Rafferty. Great interrogations, guys. And I prefer doing the interrogation videos over the courtroom videos, but we got to do everything, right?
Investigator would then meet that afternoon at the Orange County Jail to address, as the state has identified or spoken about, any settlement negotiations, plea offers, and under the other category to address what the digital exhibits are. They would provide you those on a USB drive, and they would identify for them specifically what it is that they are seeking for you to review at that point in time and have the ability to review it afterwards.
We're happy to do that beforehand, and I just want clarification by providing her the USB.
Hey, Kim, good to see you as always.
With all the narrowed down exhibits out of discovery, are we providing it to Mr. Lane? How are we physically?
It would have to be provided to Mr. Lane, who would then have to provide it to a member of the staff at the jail, the names of which I have from the captain at the jail as to what persons are involved in the laptop process. And then once that's done, I would require Mr. Lane to identify with a filing in the court, probably in the form of an affidavit, as to when, where, and how the USB drive was received by him, and when, where, how, and to whom it was delivered.
Thank you.
Your Honor, I feel uncomfortable with you supplying my evidence to the jail. So I don't know if there's a way that, I don't know if you are aware, but my jail phone calls have been released, and there's a lot of things that have been released from the jail. So I don't know, I do not feel protected by you all handing it to the jail. I know that Mr. Lane and I previously have worked on the laptop with USB drives that he has furnished himself, bringing in from the outside. So I didn't know, and I would feel more comfortable if there was a process or a procedure. I don't know who your names are from the jail. I do know the captain, whom I spoke to the other day regarding my laptop. But I would very much.
Who was that, ma'am?
I'm sorry?
Who was that?
For which?
The captain that you spoke to. Who was it?
D. Giovanni.
Okay.
There's multiple sergeants involved, and I did meet the gentleman who was supposed to be here today to pick up the USB drives. So
Amy, I didn't see the picture on Discord of Wendy looking extra unhinged. No, I just had a quick look and I can't see one. Was it in one of the groups? Which group?
I don't feel comfortable, please, with providing the USB drive of my evidence with things that have been leaked or released from the jail. So if there's a possibility, please, I would like for my investigator to have that and bring in with me prior.
If I understand the jail's protocol, which I read to you at our last hearing, the jail will keep custody of the USB drives and release them with the laptop as well. So I don't know how I can bypass that process that they've created, because the USB drives and the laptop, when it's checked out by you and when it's returned by you, is all going to be logged in their IMS system.
Right, it's simply a laptop. It's a very basic laptop where anyone affiliated with my case has any type of digital evidence they bring in with them from the outside. It's simply a basic laptop that we are able to utilize at the Orange County Corrections Department. That's how we have done that prior. So I don't know what it is different, and I don't know the jail protocol because no one's included me.
You were provided a copy of it through the court filing, and I read it to you at the last hearing.
Yeah, I just saw that, Amy, on Discord. She's just, I've seen it before, this picture, but she's holding a can of Coke. And can we share it on here? Look at this, guys. Wendy looking more deranged than ever. Check it out. What a horrible woman. Just, you can see it, right? She's not a normal person that did a bad thing. She's different. She's demonic, right? She's possessed. What the hell? Nobody looks like that, okay? Nobody. Stay away from people that have this vibe. They're dangerous, and they're just stay away from them. Thanks, Amy. Oh, if anyone else wants to come and join our Discord community, guys, there's a link in the description. It's free. We share great things about the case, all the cases, but obviously we've been doing a lot of Adelson content recently. So there's a lot of Adelson stuff going on. We've got a group on there called Adelson's Anonymous, right? And you can join that. It's free. Link in the description. It's great. It's fun. Everybody's there. And you're missing out. Like the video, subscribe to the channel. Oh, lost the audio, I think. We need to just cancel this. Hang on, guys. Hang on. Stop screen.
What are their names?
There's multiple sergeants.
What are their names?
I'd rather not get involved with fear of harassment or anything from other.
Ma'am, I'm deferring to what the Orange County Jail and the captain that you identified specifically as to her memorandum to the court, which was read to you at our last hearing, which was sent a copy to you by a notice of service, and it was provided by U.S. mail. It was sent out last week.
I have yet to receive anything such as.
Don't worry, I have a copy to give to you this morning, just in case you have not received it.
Yes, the last thing I have is your order that you provided me with the implementation of your USB drive.
Okay.
Option.
All right.
So anything that you are speaking of in the meantime, I do not know, and it was served by process?
It was served by U.S. mail.
By U.S. mail?
Mm-hmm.
Yes. I actually have 3 motions, please, if I may submit them to you.
In a moment.
Yes, in the process of, because the address that you are, I'm guessing, sending these to is incorrect.
I received your letter addressing the address issue. That's been remedied. So the appropriate legal mail address will be utilized. It was simply a clerical error, and that has been remedied. But regardless, I did read to you at our last hearing the protocol for the USB drive in the jail. The court is inclined to follow the Orange County Jail's protocol with regard to the USB drives. So the evidence, digital evidence that the state seeks to admit at trial will be put on a USB.
They do look like pink handcuffs, Leslie. And I guess it's just reflecting the carpet or something. They can't give them pink handcuffs, can they?
B drive delivered to Mr. Lane. That will be delivered to a representative from the Orange County Jail. And Mr. Lane will thereafter file a filing with the court in the form of an affidavit identifying when he received it from the state and who he gave it to, when he gave it to, and what representative of the jail he gave it to.
Yeah, Kim. Sarah does turn every answer into a question for the judge, but you know why? Because she wants it put on record, on the court stenographer record. There's someone taking down every word she says, and it's building a record of her grievances with this process, which is massive grounds for her appeal, given the fact that she's been forced into self-representation and all this stuff about where she's reviewing her evidence. Will the media see it? Because if the media disperse information about her evidence to the jury pool, which is coming out of Orange County, that could compensate the integrity of her right to a fair trial. I mean, you could not have more grounds for appeal. But I think the state are hoping that this doesn't even go to trial, because Mr. Cacciatore is probably going to collapse midway through his opening statement if he doesn't have enough crack, right? And What if she wins? I mean, she's not going to win. If she's representing herself, speaking to a jury and trying to explain her actions, that is not going to go well. Okay. But why would the state not want it to go to trial? I'm starting to think that the state don't really care what happens. They just need to put it through some official procedure, whichever one it is, to get it out of the way and away from them. So they can't just let her go because there's no procedure for that. But there is a procedure for a plea agreement, right? You agree to do another 5 years on top of the 5 that you've already done. That's 10. The charge is manslaughter, and you're out by the time you're 52. You'll have another 20 or 30 years of life while George is in the ground. You know, how does George's family feel about that? Well, if it were my family, if it were me, like if I was George's dad, I'd be like, hell no, go to trial, no plea agreement. Isn't that the case where the family has a say if there's a plea agreement? I remember in the case of Chris Watts, the prosecutor flew from Colorado to North Carolina to go and speak to Shanann's family and ask their advice. And their advice was, look, offer him an agreement because we don't really agree with the death penalty, even after what he did to our daughter and our grandchildren. So families have some say, don't they? I mean, where are George's family? They should be campaigning. #Justice for George.
So it goes from the state to Mr. Lane to the jail.
For the purposes of indexing it, for the purposes of their records under the protocol, and then it will be available for your use.
So if I want to see all of my evidence digitally, I need to contact someone at the jail.
No, ma'am. The evidence that were in the 2 bankers box that Mr. Lane digitized for you is going to be provided to the jail. That's going to be provided with the laptop to you. And that's available to you from 8 a.m. to 4 p.m. every day in the protocol that I read to you at our last hearing.
Yes, and I will speak to the captain just to be aware that everyone that it is in the process, because I do not feel comfortable with any of this, and I do not feel protected either by the courts or the jail system. So for right now, I don't know if it can be postponed or if it's something that I need to write another letter to. Everything takes longer in jail. So by me trying to get a hold of the captain nonetheless, it's going to be a feat in itself. So I want you to know, if anything, that I am in the process of trying to reach out to the captain. I don't know if she'll be here today or if it'll be the contact person. So in the process, I am working on speaking to the captain because I do not feel, like I said, that I am protected in any way, shape, or form by the Orange County Corrections District withholding my evidence in any way, shape, or form.
Okay. The court's going to follow a procedure as I outlined at the last hearing.
Yeah, Mary. Sarah Boone is the Orange County Winter Park alcoholic that was playing hide and seek with her boyfriend George, and then forgot to let him out of the suitcase, went to bed and passed out, and came back downstairs 12 hours later, and he was dead and purple and stiff. And yeah, she was arrested the next day. And that was in 2019. Or was it 2020? I can't remember, but I think it was 2019. It was just before COVID. When was COVID?
So here's what we will
Imagine that. Hey? You go into jail, you wake up completely monged, hungover, your boyfriend's dead, you have a really difficult interrogation, then you're in cuffs, they take your cigarettes, put you in jail, and at the same time, COVID hits. So you're going through all the social distancing adjustments and masks and lockdown in prison. What a culture shock that must have been.
We will, on Thursday, September the 3rd at 9 a.m., we'll have a hearing to review the physical evidence. At that time, the state will provide its exhibit list which will be filed with the court at that time, and a copy will be given to Ms. Boone of the physical and the digital evidence they are seeking to admit. After we have the in-court examination of the physical evidence.
Hi, Cheryl Sharp. Always good to see another one of our YouTube members representing the team. Good. Nice to see you.
That afternoon, there will be a meeting at the Orange County Jail between the state, its investigator, Mr. Lane, Ms. Boone, to review the digital evidence and provide a USB drive with that information.
You can caveat in that order be unless it hasn't already been done.
She's 46 now. She's born 10-10-77, so she'll be 47 on October 10th.
In case we do it ahead of September.
Sure, if you want to do it before, the deadline to do it will be to September 3. But the in-court physical examination will be at September 3. So if you all want to meet in advance of that, I won't prohibit that. Just file something in the court file identifying a notice or some documents.
Absolutely, Amy. I can't wait to get on to Juan Martinez cross-examining Jodi Arias. What a show that was, huh? I mean, it takes I think the cross-examination alone is 9 or 10 days of testimony. That incredibly fiery battle that we witnessed. I mean, I'm probably going to have to fight. I don't think, as much as we all want to see it, and especially on the Metrics channel, do we really want 10 days of it? I might try and find a way to cut it down to the best bits, but that's going to be difficult because the whole thing is great. Yeah, there's a few other things I want to get out of the Jodi Arias case. It was one of the first ones that I watched completely, and then again and again and again. What a case, what a show that was. Yeah, we will be getting back to the Jodi Arias case, Amy. We did Jodi's interviews on our channel page. And what else did we do? We did Ryan Burns' testimony. Yeah, that was good. Yeah, here it is. Look. On our fantastic channel page, guys. Yeah, God, we're putting out so much. Hey, Jodi, here's Jodi and her interrogation. We did a bit of that. And then Ryan Burns testifies. That was quite funny. But yeah, then we put it down for a little bit. Didn't really get the numbers on Jodi. Kind of surprised me. I thought it was a really, really popular case. I mean, I know it was a long time ago. It's not very current, but it's one of the best court footage available on the internet, in my opinion. Anyway, anyone wants to check out our channel page, go and subscribe to the channel. You could watch this all day long for nothing. If you want to support the channel, you can buy me a coffee on buymeacoffee.com, where you can buy us a coffee.com on our fantastic yeah, look how easy that is. Memberships, guys, memberships. Fantastic memberships. We got a beautiful new member the other day, our good friend. And the memberships have really been rolling in on YouTube as well. Don't forget Patreon as well, guys. We've also got Patreon now. That's 3 platforms where we've got fantastic benefits on the membership packages for True Crime Metrics. Like the video, share the video, subscribe to the channel, and do all those good things. It helps us. It helps you. It helps us help you and bring you even better content more often, because we had to take a day off yesterday. We don't usually do that. It's daily streams all the way up to Donna's trial. Then we're doing the whole thing live, right? The whole thing, Donna's trial. And if we are going to see a Sarah Boone trial, I'm not convinced at this point. We'll be covering that too, live.
So that it identifies when that meeting took place, when the evidence viewing took place. Okay, thank you very much. Ma'am, after we've had this hearing on September 3, and that being the deadline for the digital evidence and the viewing of the physical evidence, the court would then like to set a deadline for when you would provide your objections to the state's exhibits. Mindful that this will take place on September 3, and that we have pretrial set for September 26th. And if we need to have a hearing with regard to those objections, my thoughts would be to give you 2 weeks until the 17th to lodge your objections. And those would need to be provided in writing by the 17th. So that if there are objections, and if we need to have a hearing on them, that hearing can be held when we have our pretrial on the 26th. That would give the state ample opportunity to prepare for any of the objections that you have.
Forgive me, and thank you for your patience, everyone. So on September 3rd, I will be viewing the digital and physical evidence here in the courtroom.
Correct.
And then later that afternoon, I will be meeting with the state and my investigator.
If they don't meet with you prior to that date. The deadline for the state's investigator, your investigator, and yourself to meet to review the digital evidence would be no later than the close of business on September 3. I've outlined for when I would like it done, but if the state wants to meet you in advance of that date, they can do so.
Yes, please. If I may ask, please, what is your name, sir?
William J.
Could you spell your last name, please?
J-A-Y. Don't get that.
And what is your affiliation with the state?
I'm a homicide unit chief.
Yes, please. And I am okay if you would like to meet prior, so less time is consumed on the day of our meeting, supposedly on the 3rd.
So I assume you have availability. Should I meet with Mr. Lane to discuss his availability so we can get out there this month?
Yes.
Then you can do that. And like I said, Mr. J, if you could follow that notice, just identifying when, that would be most appreciative. So ma'am, understanding where we are with the viewing, what is September 17th for the deadline for your objections acceptable to you?
Yes, and if I may please raise the point that I have a motion here in regards to going into process.
Absolutely, Spacey Dove. We will be covering Stephanie Lazarus's interview, and that is quite short. It's only 45 minutes long, I believe. Yeah, but what a show that is. That is, I've been waiting to do that. I think we'll do that next time we have a Sunday fun day, because it is kind of a one-off, situation. There's not much other content about her. I don't even, was there a trial? I can't even remember if it actually went to trial or not, but if it did, either the content's not available or I haven't seen it. But the interview is fantastic. The story is fantastic. Maybe we'll do a little introduction video about the story and then have a look at the interrogation, and we'll put it all in one show. We can do a nice 2-hour special on our next Sunday fun day, guys. So yeah, I think that'll be our theme for now. You know, we'd like to do, you know, we've been doing a lot of Adelson case stuff because we're all embedded in the run up to Donna's trial, and everyone's getting excited, and it's great because we're kind of, there's been 3 trials already, right? So we kind of get to go over the evidence again and see and refresh our memories about what the state is going to bring to the table for Donna's prosecution. So that's been really good. So we do these things where we stay on one case for bits and pieces, but I think a nice thing to do would be Sunday fun day, when we just do a random one like Stephanie Lazarus. Another one that I've been thinking to cover is the case of those 2 young guys in Ogden, Utah, where they went into a park at night to have some beers and to smoke some joints, and they saw a homeless person camp up in the distance, and they went over there, and there was this guy on the sleep next to the fire, and they just shot him in the face and ran away, and the cops just immediately pulled them over, brought them in for questioning. And that was a horrific case. And the interview, again, it's quite short, just about an hour. So with our commentary, we should be able to get a 2-hour show, a 2-hour metrics show out of that for another Sunday fun day. If that sounds like something you don't want to miss, guys, make sure you're subscribed to the channel and clear any bookings you have on fun day for our metrics Sunday fun day. Like the video.
Also working on it for the laptop. I do not have my discovery as of yet, and I do not have the laptop as of yet. I I do not know what hiccups may be involved. There's a lot of hiccups with the jail already. So I'm trying to figure out when and where I'll be able.
Yeah, that's a good legal term. Hiccups at the jail.
To view anything, so there's a great restriction also that is being put on the laptop usage from 8 to 4. I'm unable to utilize my time to the full extent. Also, I have a motion here to receive my hard copy evidence because when the laptops are in quotes, the laptop is in quotes, closed for the day at 4 p.m., I can therefore pick up using the hard copy evidence.
I haven't had the opportunity to review the motions that you're speaking of, neither has the state. We'll address them today. I don't have a problem doing that. I'm just not going to do it right this second because I haven't had the opportunity to review them yet.
Yes, and I'm just explaining myself in the meantime, please, so you're aware of what I have already thought of and am trying to.
She does this thing where she says please after sentences where the word please doesn't belong, like Dalia Dipolito in the interrogation cell when it's been revealed to her that the cops know that she put a hit out on her husband, 5,000% sure and all that. She's like, I don't know what's going on, please. I don't know what's going on, please. It doesn't make any sense. Is it 2 sentences? What is that? I don't know what's going on, please. Please.
To ease the pain of everyone with me trying to figure out how to do everything and when and do it appropriately. But I just wanted you to know that by bringing that topic up, I have that to also be looked over.
Okay.
Please. 9/17, if that has to be changed, am I okay to do that?
I'm trying to set deadlines now, ma'am. And that will give you 2 weeks to review the physical evidence. You'll be provided the digital evidence, it seems, in advance of that September 3rd deadline. And that may give you more than 2 weeks to review and lodge any objections.
This is just for the evidence?
Correct. This is only addressing any objections to the evidence that the state seeks to admit.
The digital discovery, is any of that included in that?
Yes.
Okay. I am very weary to make these type of deadlines.
Well, we're setting them today.
I understand. So the 3rd is a what day?
Thanks so much for the super chat, Mary Bartlett. And yeah, love watching this channel grow. We're growing up real quick, huh? We were just knee high to a grasshopper not too long ago. It was less than a month ago that we were at 1,000 subscribers. Huge landmark, right? Huge landmark. And since then, we've had another 400. I mean, is it just me, or is this really quick? Like quicker than, it seems to be quicker than the norm, which is great. And I can't thank you guys enough. It's been a fantastic ride. Thank you so much, Mary, for your super chat to help the channel grow. Great example. Great example. Well done.
Thursday?
Tuesday. So the 17th would be 2 weeks later, Tuesday the 17th.
And that is me coming with my objection.
That would be you filing your objections in writing with the court. And to the extent we would need to have a hearing on those objections, we would have them when the pretrial or trial case management conference is set at 9 a.m. the following Thursday, the 26th of September.
I'm sorry, what is on the 26th?
That's when we're having our pretrial or trial case management to address any last minute issues regarding trial.
Forgive me. So today being August 5th, I'm supposed to expeditiously complete my case.
Hey, Amy says that she wants to go to Tally so bad for Donna's trial. Her hubby doesn't want her to travel alone because no one else in her life cares enough to sit in an 8-hour trial, in a trial 8 hours a day on vacation. Amy, connect with someone on here, have them meet you at the other end, and tell hubby to shut up. Get to the trial. You know, there's a huge community. There's several people from the metrics universe going to Donna's trial, and they're all very nice. You know, get yourself a hotel, get in that trial. Definitely go. Definitely go.
In every way.
Nothing could stop me apart from an ocean. The Atlantic Ocean can be a real bitch sometimes.
She was informed by September 26th in order to go to trial for October 7th.
The dates are what the dates are. September 26th is the trial case management date, and October 7th is.
It's another t-shirt, guys. The dates are what the dates are. I'm so glad we have this court hearing to define the dates are what the dates are.
Is the trial date.
So by me not even seeing my discovery yet 2 days, and only being restricted to a laptop from 8 to 4 and not having my hard copy evidence.
You have 62 days to prepare for trial, not including today. And you're going to get your discovery.
Thanks, Amy, so much for that super chat. And yeah, I did see the Reddit post where they're all like, hey, what's your favorite true crime channel? And people are going, love metrics. You know, long chain of posts. Well, not all about this show, but certainly a bunch, which is fascinating to read, you know. And I'm sure we've got some new viewers coming and saying, hey, what's this metrics all about? And maybe they like it, maybe they don't. Maybe they're here to stay, maybe we'll never see them again. But it's all good, you know. It's some people like this format, some people don't. But I have not had much time to be checking out other people's channels, but I kind of did the other day, and I realized that what we're doing here at True Crime Metrics is very different to what's out there. The general format of trial discussions, interrogation discussions, I find it quite samey out there in the other channels. Don't get me wrong, there's lots of channels I like. I wish I had more time to spend watching them, but yeah, there's many that are basically all the same with different people. And yeah, I do like that we're quite different from the general resource of what's out there
Today.
Wow. So in over 4 years, it comes down to me representing myself in 62 days.
I'm not going to answer that question.
Am I supposed to?
What now we're addressing, ma'am, is September 17th.
Right.
The deadline, which is 2 weeks after having the physical view of any of the physical evidence. It sounds like Mr. J is going to try to meet with you pretty promptly regarding the digital evidence. So you'll have plenty of time to review that in 2 weeks at a minimum, or 2 weeks at most, rather, to lodge any objections to the physical evidence.
I understand. I just don't understand how to file objections.
I cannot answer that for you. That would be me providing you legal advice, which I'm prohibited from doing. All I can tell you is that if you have objections to any of the exhibits that the state may seek to move into evidence, you will have to lodge those objections by the close of business on September 17th. And those objections will have to be in writing. If we have to have a hearing on those objections, that hearing will be held on September 26th.
Okay. And if I may ask, are these being delegated or I'm being incorporated in this in order for me to be able to say yay or nay?
I don't know what that means. What do you mean delegated?
Are you delegating to me as you've delegated everything else in regards to taking my counsel and all of your orders?
You are representing yourself for the reasons that the court identified in its 16-page order. It is your responsibility as you are representing yourself and proceeding pro se.
Leslie, do I work in law in Portugal? No. Yeah, people are always asking me, what do you do? What do you do? What's your day gig? What's your day gig? Well, it's a lot of different things. It's not law. No, I just like I find that these resources are a really good example of human behavior, of psychology, exposure. I think the reason I like doing this so much is that it helps me better understand personality types I encounter in my own life and my own. I see, it's an analysis thing, but it's also funny sometimes, a lot of the time. Yeah, that's generally why I do it, I think.
To comply with the court's orders and deadlines. So if you have objections to any of the exhibits that the state may be seeking to offer into evidence, be it digital or physical, based on your review of those, the deadline to submit those in writing would be on September 17th.
Okay, so you're making statements, so I don't have any say in it.
I've asked you what your thoughts would be as to when. You've never provided me in a disagreement with regard to that date as of yet. You've asked questions about your motions that I haven't seen yet, your desire to have hard copies, which we addressed at the last hearing, but I'll be glad to address it again today. You have yet to tell me that that date's unacceptable for you, and if so, why?
I wouldn't necessarily say unacceptable, I'm just uncomfortable with agreeing to a date when I am pro se and have never been pro se before and do not know what I'm doing. So I just want to make sure that I do it correctly and have an understanding also if you are proposing that I go to trial within 62 days, that I know what I'm going into and what I may expect. So I didn't know if this would just be easier on everyone else, if they just delegated the date and gave me a printed copy with your order and whatever information you have. I don't know. I don't know either if you all are just...
Hey, if anybody wants to check out the Reddit post where everybody's talking about metrics, I just put a link to it in the description for this video. Okay, it's just under the description. Yeah, and there's also great links in there to support the channel, guys, or become a member. Social networks, Facebook, Twitter, Instagram, and Discord.
Proposing that because I'm incarcerated, just the dates are what you tell me. I don't know what I'm doing. I do not know what I'm doing. So I'm trying to learn as I go, which is why I'm grateful for everyone's patience. But at the same time, though, for me to accept this date and then not be able to meet it, what happens when that happens, if it should happen?
I can't answer that question. Again, that would be me providing you legal advice as to what to do if something happens. I simply cannot answer that question. I'm not allowed to.
Okay. Well, I'm with the court, so whatever it is that you all are trying to do in order to expedite this even more than what it's being expedited, I'm guessing I agree with September 17th.
Okay. All right. Now, ma'am, I believe that takes care of all of the deadlines with regard to the state's exhibits. Now I want to address deadlines for any exhibits.
I agree, Clarissa. The least that they could do is give her a paralegal. I mean, she has no idea what she's doing. She's got Law for Dummies from the prison library and is desperately trying to come up with something, right? I mean, they should give her a top shop private lawyer and pay for it by the state, in my opinion. It wouldn't be that much more money than what is already costing the taxpayer anyway to put on this shit show trial. And they're giving her enormous grounds for appeal and to have her her sure to be conviction vacated. So it would all be nothing, and she'll walk free. George's family won't get the retribution that they deserve, and it's I don't to me it seems like the state, well, the court and the state are taking an enormous risk in handling this situation in the way that they're doing. They're basically saying you're on your own, deal with it, and by the way, we're going to give you really small amount of time to prepare. Good luck.
witnesses that you may be seeking. I am mindful that you will be receiving the discovery today and that you have not had the opportunity to review some of the items that may be in the discovery. So how much time would you like to provide to the court the list of exhibits that you may be seeking to enter and the list of witnesses that you may be seeking to have testify in a defense should you choose to put one on?
Hey, Leslie, I forgot what I said. What's true? Healthcare. Did I say something about healthcare? Sorry, I can't remember, but thanks for telling me I'm right. Which I usually am about half the time.
Understand that I do not have access to a normal phone. I don't have access to a normal phone at normal hours. So I am trying to overcome the hurdle of trying to, number one, locate any of my witnesses, and then also try to communicate with them on a payphone only telephone call that I do not have regular access to, and that are limited to only 15 minutes that I have to share with 62 other inmates. That is a hurdle that I need you to please take into consideration in order for me to be able to try to determine my witnesses, to determine any expert witnesses. May I ask, please, does the laptop have internet access?
I'm unaware. I'm unaware if it does.
To view any document?
I would think not. You know, are they going to give her access to the internet? How would that even work? No. Let's just say it's a 95% likelihood that there's no internet access, Sarah, okay?
I'm unaware. I can't answer the question that I don't have an answer to. I'm unaware if it has internet access.
Whom is it that I need to speak to in order for this?
We may be able to inquire of the jail representative who is appearing for the hearing this morning, and if not, the captain may be able to provide that information, but I do not know if it has internet access.
May I ask your contact names from the jail?
Give us 1 second.
Please, and also because of the
This reminds me of the list of questions that she brought into the interrogation. So do you all tell his probation officer or do I? What about his engagement ring? I bought it for him. That'll be going to the next of kin. Well, I'm not getting that back. Oh, man. Sarah, I think you're going to hear that list of questions at your murder trial. I think they're going to be read out to the jury because they make you look really bad.
court's error of sending my information that you're referencing to the incorrect address. Could you please provide me a copy of that also?
What is it that you're asked? Which, the protocol, ma'am? That was what was most recently sent.
I don't know. Whatever it is, the last thing that I received from you in the court was the hand delivery of the order regarding
Sure.
USB.
I have a copy that Madam Clerk's already printed out of the protocol. We will have the deputy hand deliver that to you right after. Give me what I did. You know. Oh, I sent it to Anita. That's why. Give me a second. I'll have Madam Clerk print that out for you right now, ma'am.
Thank you.
So understanding that as of right now, you do not have hard copies, you'll be provided digital copies. And to review all this evidence, ma'am, when in time do you feel comfortable in providing the court and the state the list of your witnesses and your exhibits that you may be seeking to introduce?
I'm going to go with to be determined because I just explained also, please, that I do not have access to a regular phone. I need to locate anyone. I need to do research. I don't know if I have internet access to anyone. I don't have a phone book. There's no way that I know how to do any of this without essentials and fundamental equipment in order for me to be able.
Okay, yeah, no, I get it, Leslie. Yeah, that's what I like best. That's why I'm really myself. I'm not so much into the really like sick shit. Tailorship business. People ask me, oh, do you want to cover the tailorship business? And not really. It's just a meth head who chopped up her boyfriend and hid all his body parts in his mother's basement, which she found her own son's severed head in a bucket with a tea towel over it. You see, that doesn't. I like cases that are about like the Adelson case is great, in-depth manipulation, planning. There's a lot from my own life that I think that's the main thing with the Adelson case. I think a lot of people that aren't necessarily into court and crimes like the Adelson case. It sort of has a further reach because it's got so many personalities and archetypes of people that are recognizable. And this one, for example, my previous girlfriend, I showed her the video about Sarah's interrogation, and I said, look, this could have happened to us. You could have put me in that bag. And she goes, yeah, you're right. We're not together anymore.
Provide you with those answers. I cannot promise anything because I do not know how I would be able to do any of that at this moment. I would like please to propose your understanding of a meeting that I would like to have with the captain so I can see if I can have access to a regular phone, if I can have access to an internet. Right now I have a tablet that is used for text messaging and movies and the law library that I utilize. I don't have access to the phone, I don't have access to the internet.
You can certainly have those conversations with the jail representatives. But ma'am, we were on notice today to address those deadlines, and I cannot set a to be determined deadline at this time. I understand that there's been some delays with regard to discovery. As I told you at the last hearing, we're moving as expeditiously as possible to get you that, and it took some time for that process to be created. That process is going to start today. Mr. Lane's here. Representative from the Orange County Jail will be here. That handoff will take place. You'll have access to that laptop with all the information today.
If the defendant's not going to make a suggestion, make a state.
Sure.
My suggestion would be to give her 14 days after the point that the specific evidence identified by the state to be used at trial is provided to her. So, for example, the physical evidence, which we plan on giving her the list of those physical items well in advance of September 3rd. That will just be the date that she can actually see them. But my suggestion for those physical evidence items would be September 17th, and then 14 or 15 days after whichever day we get the specific list of digital evidence items to her, would be our suggestion.
Okay. Ma'am, are you amenable to that? That would 14 days after you've had the opportunity to review the digital evidence and 14 days after you've reviewed the physical evidence to provide your exhibit lists.
I don't feel comfortable with any of this. I don't have the same opportunities as the state or any attorneys prior. So I feel that you all are pressuring me and forcing me into these things which I may not be able to meet or exceed.
Can I add that obviously either side, if there's good cause for why a deadline wasn't met, if something comes up, then we're not prohibited either side from complying with the rules of discovery afterwards. But there would just need to be a cause shown.
Do you understand that, ma'am?
I do.
That I'm setting these dates for now, and if either party can establish good cause why these dates should be moved.
Yes, and that is why I'm trying to make everyone aware prior to all of this to understand my circumstances.
Yeah, Mary says her whining will come to an end soon. When? This is Sarah's big tactic, right? If she hires a car and returns it late without any gasoline in it, and the hire car has a problem, she will talk to them for 6 hours like this, round in circles, until eventually they say, just go. Okay, that's it. No charge. We've had enough. To just wear people out with this horrible voice, these ridiculous questions. That's her whole tactic, right? Or if she wants something taken off the bill in the restaurant, she's like, "Will I see the manager, please? Can I see the manager, please?" And then 3 hours later, she walks out the restaurant with a free gift card that they gave to her just to get her out of the building.
And by being incarcerated and not.
And she thinks she's smart and like that she won the argument, won them over. Not true. Not true. They just had enough of listening to her.
Having access.
Sadly for Sarah, it doesn't work that way in a court of law because it has to be procedure, right? Not going to happen. It'd be crazy if she walked out of this, huh? We're so used to seeing justice delivered firmly and appropriately because we've been all watching the Adelson case so much, and it's just line them up, knock them down, right? But sooner or later, guys, I mean, I didn't follow Casey Anthony when it was happening, but what a mad ride that was. And she walked out. She got acquitted, not guilty, found not guilty. Are you kidding? Sooner or later, something crazy like that is going to happen again, and we'll be sat here front and center on Metrics, on True Crime Metrics. Subscribe to the channel.
Not having access to the internet and not having access to any more other, like I said, basics, fundamental basics, which is why I'm making you all aware now, so you are aware that when the time comes, should it, why for good cause, I'm stating my good causes now, if not, there are additional at that time.
Ma'am, as of right now.
Yes, Amy, there's an interview with her ex-husband, Brian. I think it's the same day as it all went down. It might have been the day after. And there's also a follow-up phone interview that Detective Chelsea, that's her first name. I don't know what her last name is. Detective Chelsea speaks to Brian on the phone. So there's 2 interviews, and Brian really throws her under the bus. And I kind of took a bit of an issue with that because, yes, I know that she was a complete nightmare and made his life miserable and everything, even after the divorce, and especially after the divorce in many ways. But I for the longest time, and maybe my opinions have changed about this now, but for the longest time, I thought to myself, if it were me in those shoes, I would not be throwing my ex-wife under the bus, no matter what, especially when it's the mother of my kid. You know, that's whatever they did, you know, it was difficult for me to get my hand. He's basically going, yeah, lock her out, take her away. And I just couldn't see myself doing that. But maybe my opinion's changed.
The court is inclined to agree with the state's suggestion that 14 days after viewing the digital evidence, which will take place.
But hey, his interviews are very good. I think we did cover some of them somewhere in our Sarah Boone content, but I don't think he's on the picture because it wasn't a video recording, but we put it at the end of one of the Sarah Boone videos. So find the needle, guys.
No later than September 3rd. Sounds like it'll take place way in advance of that. You are to provide in writing your list of exhibits that you want to attempt to move into evidence. 14 days after viewing the physical evidence on September 3rd, you are to provide in writing the list of any exhibits that may be physical that you intend to enter into evidence. Those dates can be extended for good cause that may be shown. State, would you like the opportunity to review those exhibits similar to an evidence viewing that we're having with Ms. Boone reviewing the state's exhibits? Would you like a similar opportunity to review any of her exhibits?
If the defense has any physical evidence to place in evidence, I can make those arrangements with Mr.
Okay, all right. I will set a deadline for the review of September 26th.
Thank you.
Is the review that you're seeking out, please, for my exhibit?
Completely agree with you there, Neverly. Yeah, no, not only would I throw Wendy under the bus, I would set the bus on fire and and hit her with a flaming bus. Okay, that's what I would do with Wendy. Yeah, she's the exception to the rule. You're right. You're absolutely right.
That is correct. I would also propose a similar date of September 17th for any of the witness lists for the defense. And Mr.
Yeah, Amy. Well, EI in Portugal sounds like A, if you know what I mean. Like Leila. Leila.
Mr. J, would you be in a position by the 1st of September to provide any witness lists for the state?
She should have the witness list in the discovery that's being provided. As far as the order and the list of witnesses that we're going to call at trial, we will get in that ahead of 9/3.
Okay, all right. So the deadline for the state's production of the witness list will be September 3, no later than, and September 17th for Ms. Boone. Ma'am, similar to the objections to any discovery, that'll have to be in writing as to who it is that you may be calling as a defense witness. You'll have to provide that to the court in writing by September 17th.
Yes, and if I may ask, please, what you're typing, is that for an order or for today's proceeding?
It is for an order, which you will be given a copy of. It may not be able to be hand delivered to you, ma'am, because I'm gonna have to move some stuff around based on my scratch notes here, but at a minimum, it would be mailed to the your proper address. Due to that clerical error, that will not be an issue.
Wonderful, thank you.
Okay, I think that addresses all the issues with regard to production and hearings on any objections. Anything else from the state that you believe we need to address from a scheduling concept?
We're good with the scheduling concepts. Thank you, Judge.
Thank you. Ma'am, do you have any questions with regard to the scheduling concepts or deadlines that we've addressed this morning?
Other than what I have made known to the court, I do not.
Okay. Bruce, can you see if Mr. Sergeant Casey's here? He is here. All right, very good. Sir, could you come on up, please? Madam Clerk's going to go ahead.
Leslie, that is the guy from, I forget where he's from. But he's just a representative of an agency that's involved in these proceedings. I know that kind of sounds obvious. It's not just some random guy looking in. But yeah, I can't remember the name of the agency. But he hasn't really said much anyway. So I don't know if it's that much important, really. They did say at the beginning. I just can't remember what it was.
And swear you in. You can stay to the podium, sir. No, just the podium, Sergeant.
Oh, sorry.
If you could raise your right hand, Madam Clerk can go ahead and swear you in.
Swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
All right, sir, good morning. Could you state your name for the record?
Sergeant Donald Casey,
And what's your position at the Orange County Jail?
Sergeant.
And what are your duties and responsibilities, sir?
I'm over transportation, downtown port holding, BRC ports, medical security, and the juvenile assessment center.
Okay. Are you aware of the protocol that Captain DiGiovanni created with regard to Ms. Boone's use of the laptop?
I am.
Okay, all right. Have you had the opportunity to review that protocol?
I have.
Okay. Mr. Lane, can you come on up here, please, sir?
Mr. Lane's just got back from out of state where he attended his son's wedding.
Sir, good morning. Could you raise your right hand? Madam Clerk's going to swear you in.
Please swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, sir, good morning. Could you state your name for the record for me?
Willie Lane,
And what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator.
All right, sir, last time I saw you, I had tasked you
Yeah, I think it's just him, right?
with digitizing 2 bankers' boxes of information. And you said that you would endeavor to accomplish that task by today, understanding that you were out of town for your son's wedding. I hope you had a great time. Were you able to fulfill that task, sir?
Yes, sir.
Okay. How many jump drives or drives do you have?
Of the digitized information, there's one of those. This drive here is a copy of all
Hey, Kate, good to see you. Keep your umbrella secure.
digital discovery that I have in my possession from Ms. Boone for the court's needs if they wish to facilitate that through the, figure it'd be easier to facilitate it now through the jail than me trying to bring it in myself.
That's exactly my thought. So you've shown to me, sir, a small thumb-sized USB jump drive. That USB jump drive is the information that was contained in the two bankers boxes, correct? And the other jump drive that was the larger of the two, that jump drive is any digital information that you've had previously by virtue of being the investigator.
Yes, sir.
Okay, all right. The record's going to reflect that information is going to be hand-delivered by Mr. Lane to Sergeant Casey. So Sergeant Casey, if you please take custody of those two thumb drives. And I'm going to ask you, sir, to comply with the terms of the protocol, to have those added to the laptop. It'd be available for Ms. Boone's use today once she's returned to the Orange County Jail. Do you have any questions for Mr. Casey?
No, Your Honor.
Okay, sir, thank you very much. If you could proceed with that task, I appreciate you. Thank you. Mr. Lane, you took custody with you, sir, as well. Well, before you leave, Sergeant Casey, state, do you have any questions for him?
No, Your Honor.
All right, ma'am, do you have any questions for Sergeant Casey regarding his compliance with the protocols provided to be by the captain of the jail?
Mr. Casey, could you please make note to Captain Giovanni that if she has time.
Okay, there's about 30 minutes left, guys. I'm going to try to cut in a bit less so we can wrap this up under 3 hours, okay? Just a reminder to leave a like on the video, guys. Subscribe to the channel. There's a link in the description to the Reddit post, not made by me, made by a random person that's mentioning us. And then a load of other people are like, yeah, Metrics is my favorite show. So if anyone wants to read that or go and add to it, say, yeah, Metrics is fantastic and all that, all you Reddit lovers out there, the more the merrier. I mean, there's already a bunch of people talking about the show on there, but I guess it's really good for our exposure, right? So that would be another great way to support the channel. If you're always on Reddit anyway, what are you waiting for? Check out the post, leave a comment, tell everybody about how great Metrics is.
Time at some point as soon as possible to please sit down with me for about a half an hour to go over quite a few things that I need to have resolved.
I'll look forward.
Please, in regards to the laptop.
Okay.
Thank you.
Thank you very much, sir. Mr. Lane, when we were last here, you also had two bankers boxes. Did you bring those back with you, sir? Okay, could you bring those back up? I do see it looks like the original exhibit tags are still on the top of those. Mr. Lane, did you complete and copy everything that was in both of those boxes?
Yes, sir.
Okay, I'm gonna have Madam Clerk take possession of what was pre-marked as A and B for the purposes of the June 28th hearing, and we'll hold those into evidence. Do you have any questions, Mr. J, for the investigator with regard to his task?
No, Your Honor. Thank you.
All right, ma'am, do you have any questions with regard to your investigator regarding his completion of the digitized process?
And my only question is, Mr. Lane, do you know when you would be coming to meet with me at the jail?
It's going to be my intent to try to get out there at the end of the week or beginning of next week.
Thank you.
What happened?
I don't feel comfortable signing your invoice. I think Ms. Boone would have to sign it.
Okay, that's fine.
Okay.
Is it okay if I?
Hand it to the deputy. Deputy will have her sign it, and then you can take it. Mr. Lake, is that acceptable, sir? Counselor, you're muted.
Yes, that would be acceptable, yeah, Mr. Lane.
Hey, Christina, what did you try and add Metrics as a request on Discord? Or what? Let me see. I just put a link to Discord in the chat, guys, but it's also in the link to the. There's also a link to it in the description for the video, along with all of our social networks. and other ways to support the channel. Yeah, Christina, if you want to add me somewhere, add me away.
And you want to, in light of this, maybe it might be more appropriate for the court to go up to 10,000 for the investigator, because it sounds like he's already done a lot of work. So it might make more sense instead of having to come back later.
Would that change the original, the 5,500, or just we would increasing 5,000 to 10,000?
5,000 to 10,000, I think would make sense, Your Honor, just because it sounds like that we may. And
this prison break investigations is a license to steal, isn't it? I think there's a lot of these agencies involved in court process. You know, all he's done is Xerox a load of paper, $10,000. Okay.
Based on what's already been done, and Mr. Lane may have more to say about that, but based on what he's already done, I suspect he's probably used a large chunk of that 5,000 just doing this one task.
One thing I would like to add, Your Honor.
Yes, sir.
In lieu of having to come back and file another motion, is if JAC would agree to travel expenses since I'm out of county. If not, I can get that in some type of form of a writing and get it to you or to the JAC.
Yeah, I need another 12 grand for my travel expenses. I have to go all the way down to the copy shop, and I have to take a taxi with these boxes. So yeah, about 12 grand should do it.
Mr. Lake?
Your Honor, we'd have no problem with the court authorizing, saying $1,000 for travel expenses as well.
All right, fine. So we'll increase it from 5,000 to 10,000 for investigative costs, and for travel-related expenses, 500 to 1,000. Mr. Lake, are you going to need a word for the court file with regard to those?
We would, Your Honor.
Okay, could you submit that?
Yes, Your Honor, we will prepare the order and submit it.
All right, very good. Just send it to Ms. Barrios, so I believe you have her contact information.
Yes, Your Honor.
All right, very good. Thank you, sir. Mr. Lake, thank you so much, sir.
Yes, sir.
All right.
Judge Payne,
Yes, ma'am.
what is his name, please?
That's Christian Lake. He is an attorney associated with the JAC.
Yeah, very good, Rabbit. But he's the father of the groom. Is that still a thing anymore?
The Judicial Administrative Commission regarding costs for indigent defendants. All right, state from a scheduling perspective or the protocol, which I know I filed a notice of filing of. I'm sure you've had the opportunity to review it. Anything else we need to address from that?
We're good on scheduling, Your Honor.
Okay, thank you. Ma'am, anything else we need to address regarding scheduling or the protocol other than what you've already addressed this morning?
Will my investigator be present at anything for and with me?
I can't speak to for or anything, but based on what we discussed today, your investigator will be there for the digital review, which will take place no later than September 3rd.
Okay, yes, I would like to have some type of witness from.
He will be there.
Site also.
He will be there. Mr. J is going to be recording the conversation as he identified previously.
Thank you.
Now, ma'am, you made reference to some motions that you may have brought.
Christina, are you in Discord? Can you see the forum, the chat room and everything?
With you this morning. All right, if you could hand those to the deputy. Also, to the extent that the deputy has not already done so, I printed out a copy of the July 24th, 2024 protocol regarding your use of the laptop at the jail. And I'm going to ask the courtroom deputy to please hand deliver a copy of that to you. It was mailed to you. It was read to you at the last hearing, but now you have a physical copy of it, ma'am, to the extent one was not already provided to you.
Oh, yes, I have not received this yet.
Okay.
And then also there was another printout that she was going to provide me with, which I believe was a memorandum for today's date.
I haven't, is she being who, the captain?
No, I'm not sure her name.
Oh, Madam Clerk, no, the only thing she's printed out for you right now, ma'am, is that protocol. I'm going to be finalizing the order. And like I said, I may be able to finish it before we're done with the hearing, and I'll hand deliver it to you. If I cannot, it'll be mailed to you.
Yes, I understand. It was regards to another document proposing the dates for today's hearing. And I guess it was some type of notice. That's what please that she was going to print out to give to me, so I have that.
Okay. Mary.
I did not receive that, nor did I receive this protocol list.
As to everything that was being discussed, can you print out a copy of it for us? It should be in the court file. All right, ma'am, let me take a moment to review your motions. Give me a moment here.
Thank you.
And that's it. There's nowhere, is my understanding, in communications with the captain to place this information. There's nowhere to house it. There's nowhere to store it. You do not have, by your own admission, any place to place it.
Is that your understanding now? Are you asking me?
No, those are just statements that I know that are in the court file that you've made. You've written letters requesting a laptop. That's been provided to you.
I've never.
You have written letters, ma'am, specifically asking for a laptop.
Do you know what the date of that is?
Without me going through all the correspondence. But when we have our hearing on the issue of the your motion for freedom and movement, well, I'll notice the sheriff, and we'll try to set that up for this week so that it can be done expeditiously.
Okay.
We can address that at that time. But the jail has advised me they have no place to store this information, these hard copies. You've advised me you have no privacy and nowhere to place them. So I'm not saying no, but I don't know how I can facilitate this for you when you do not have a place to store it. The jail does not have a place to store it.
We have an entire property department for all of the inmates on the entire compound. I've been given permission also by sergeants.
Who?
Corporal Ward, Sergeant Dunn, Sergeant DeJesus, have the understanding that I have been forced to represent myself as pro se and have temporarily given me a property bag where I can store additional case documents at my bunk. Help me understand, please, for future reference, so I know how to approach. By my statements that I have made to you, questions were not asked in order for you to come to the conclusion that you are coming to that I did not want my hard copy. I was never formally asked by you to see if I wanted my hard copy discovery. I would believe it was the court's understanding, the judge's understanding that it should automatically be allowed to give to me. My understanding and trying to explain to you also, so you have an understanding, is my limited restricted access to the laptop is from 8 to 4. I, with 62 days left in order to defend myself in preparation for trial, would like to close that laptop at 4 p.m. and then pick up the discovery of hard copy in the 2 boxes that I have. I haven't spoken to the captain yet. I just now received the protocol for the laptop. I know that you had mentioned it.
Hey, Cam's got a good question. Does anybody know if Sarah Boone has a much needed psych evaluation? Yeah, I think they'd have to come up with a whole new diagnosis for Sarah Boone. Boone-itis. Yeah, my understanding is that would only come into play if there were, like, if she were pleading not guilty by reason of insanity, you know, then they'd see if she were fit to stand trial. But that hasn't come into play. I mean, why would they psychiatrically evaluate her right now? To see if she's competent to represent herself? Well, yeah, I don't think that's like done without a reason, and there hasn't been a reason yet.
To me, the last time we met with one another, so I'm confused how everyone is confused by me coming to the court with solutions and ideas and suggestions, but are being misinterpreted and misconstrued like my letters from my attorneys, and you're coming to the wrong conclusion.
I'm not coming to any conclusion. The process was created, and I'm just reciting what you've said to me at prior hearings, ma'am. That's all I'm doing. You've told me you have limited space. You've told me that you have no privacy and that you have a small drawer for personal effects. This is the first time I've heard anything about you having a locker or some kind of bag or property bag that you now have access to. That wasn't addressed at our last hearing. This is the first time I'm hearing about it. So I'm not drawing any improper conclusions, as I identified for you with the process. The jail created this process. It was something that they put together. And as I told you, we worked diligently to move forward to get with the jail to have this done. There's no nefariousness here. There's no undermining. There's nothing along those lines. I want you to have this information. And as I addressed at the last hearing, I could not copy it. I can't look at it. I can't look at what's in those two bankers' boxes. Ms. Barrios cannot. No one associated with my office can look at it. We had to use your investigator to do that. And what the jail has advised me is that they were not in a position to take both those bankers' boxes because of space and potential hazards. Now, if something has changed and the captain advises me that you can have those documents, I don't have a problem with you having them. But what I've been advised, as identified in that protocol, is to how and when you can have access to the information. And unfortunately, it wasn't in physical form, it was in digital form. And that was the process that the jail created. They are aware it's two bankers' boxes. They're aware of what the information is. Everything has been out in the open to address your concerns and how to facilitate getting this information to you. No one's withholding anything. No one's trying to hide the ball.
My opinion differs.
Yes, Amy, we'll put some more soap content out soon. Some little walking around swimming videos, dog swimming videos. There's not enough of that on the internet. Yeah, we got a good one actually the other day. Anyway, yeah, more to come, more to come. Soap cam.
I was never asked anything, just like my letters to you prior to you forfeiting my right to counsel. I was never asked anything in order for you to have a better understanding.
Ma'am, I'm not going to revisit that.
I am not, you never asked me in regards to the hard copy.
Hang on. Yes.
How quickly can we have an evidentiary hearing with the captain or whomever we need?
My understanding is she's on vacation this week.
Okay.
So, which is why Sergeant Casey was here, because Captain DiGiovanni is on vacation. And I cannot recall off the top of my head when she's set to return. She's set to return on the 12th.
So if the document, what would be the process? Because it's marked, tagged, and in evidence.
Oh, this is Mr. Cacciatore again, isn't it? Ready for another crack pipe hit, man. God.
So there would need to be a motion to get it released from evidence.
I mean, I would entertain an or attendance
Oh no, it's still his boss talking.
motion to have it released from evidence. The concern, as in Mr. J, this is the first time I had the opportunity to discuss this case with you. I know I've been dealing with Mr. Cacciatore. We had a hearing, and I'm sure you're versed on this, but let me just kind of bring you up to speed. We had a hearing in June, and at that point in time, I forfeited Ms. Boone's right to an attorney based on her conduct and alternatively a waiver. And I'm sure you've read it. Thereafter, the court endeavored to figure out how to get those two bankers' boxes that Ms. Cashman had provided to the court at that.
Yeah, Rabbit, as far as I'm aware, my dog is the first dog on planet Earth to be called Soap. But I was wondering, because of the exposure, and now that she's a celebrity in the true crime community, maybe we will see an increase eventually of dogs being called Soap. How about that? What a legacy to leave the earth.
Hearing in Ms. Boone's possession. It took time for the jail to come up with a policy and a procedure for that to happen. I was advised by the captain that they could not take custody or possession of those two bankers' boxes because of A, storage, and B, because of the hazard. Now, if the jail's in a position to revise that by virtue of Ms. Boone identifying a property bag or something that may be available for her use, I am 100% on board. If the jail says, yeah, we can facilitate and make that happen, her getting that information. I'm just traveling with what I've been provided and the protocol that was provided to me that's been filed in the court file was not inclusive of providing her hard copies.
I understand. I'm just trying to find a solution. So
Same.
if she moves Jorge Torres to release those two exhibits to her investigator, then perhaps he can try and get them released to her. And if he cannot, then it sounds like on the 12th, we can revisit this when the captain's back.
I think, I don't know if she returns on the 12th or that's when her vacation ends. It's a Monday, so I'm assuming she'll be back, but I don't want to make any affirmative statements on that. I don't have a problem. Mr. Lane's had this discovery. I don't have a problem with him taking custody of it again. And if he's able to deliver it to the jail and they allow it to be released to Ms. Boone, I don't have a problem with that. I have no problem with it. I'm just traveling on what the jail has advised the court in the creation of this process.
So if she wants to ori tennis, which means oral.
My God, you know, if this room didn't have on one side Sarah Boone and on the other side a crackhead and his dealer, I think this whole procedure would have been done in about 10 minutes. The judge is getting so bored and frustrated. He just wants a drink. He just wants scotch on ice cubes immediately.
Motion.
Big solo cup.
Move to release those two exhibits. The state has no objection, and it sounds like if Mr. Lane can't get them to her, we'll be able to revisit this in the near time future.
Yes.
Just so that she's advised. So I don't want to ask her, but perhaps the court can ask her.
Sure. Ma'am, the state has recommended a position for in an attempt to get you these hard copies. Is that something that you would like the court to, would you like to follow with the state's suggestion and ask of that of the court orally this morning?
I'm not understanding what it is that he's trying to do. May I please propose that the hard copies go to Mr. Lane, and then once I have permission by the captain or whomever, you can release them to me?
Granted.
No objection to her motion.
Okay. Mr. Lane, thank you for staying, sir. I appreciate you. If you could come back up here, sir, and take custody of both of those banker's boxes. I will have Ms. Barrios coordinate a hearing for the 13th at 8:45.
Yeah, chicken cacciatore. I think a chicken might prosecute this case a little bit better.
Why not? We cannot do it the 13th because it's pre-trial. You're correct. We will have a hearing on August 14th, if necessary, on Wednesday, August 14th at 1:30, if we need to address the jail's position in taking hard copies if Mr. Lane's unable to have it delivered.
There you go, Mr. Lane. Enjoy your 12 grand, man. You earned every penny. Hope you didn't get any paper cuts.
And Mr. Lane, you had advised earlier when Ms. Boone had inquired of you as to when you might be able to go visit her. You said the end of this week or by next week. If when you go to visit her by the end of this week or next week, bring that with you and see if the jail would be in a position to take it. If they are, I'm going to ask you to file a similar notice, sir, that that information was provided to the jail on what date and to whom. Okay. All right. Thank you.
Your Honor?
Yes, ma'am.
What would the hearing be for on the 14th then, for the jail taking?
The hearing on the 14th, ma'am, would be if Mr. Lane is unable to have the jail take physical custody of those two boxes for your review outside of the laptop, we would have a hearing to address what, if any, protocols the jail may be able to utilize in you having those documents. It may not be necessary. We're going to go ahead and set it if we need it. If we don't need it, we will not have a hearing.
Thank you. And then so there would not be needing to be made an updated evidence control sheet right now. It has been passed to Mr. Lane.
As of right now, the court minutes are going to reflect that what was pre-marked as A and B from the June 28th hearing is being provided to Mr. Lane.
Thank you.
Okay. With regard to your reasonable freedom motion, I'm going to set that for this Friday. Is the state available at 8:45 on Friday?
No, I looked at that date, please.
That is the 9th, ma'am.
We're available, Your Honor.
Okay, Ms. Barrios will coordinate with a representative from the Orange County Jail to address the reasonable freedom motion. Ma'am, I'm going to hand file both of these motions with Madam Clerk, okay?
Thank you.
All right. Is there anything else we need to address this morning, State?
Norma C, you're late. How you doing, Norma? Yeah, I think we're coming to a close on this. Coming to a close. Good to see you.
State.
Anything else we need to address, Ms. Boone?
Please bear with me, yes, please, one moment.
Uh-huh.
What was the conclusion for the sensitive issues of having the media incorporated in the courtroom?
I need to research that matter a little bit further before I can make an order that would prohibit media access.
Do you know what your deadline may be or estimated?
It'll be well before the 3rd. That's deadline is set for September 3rd at 9 a.m. when we'll have that viewing. I will endeavor to get that done as quickly as possible. Ma'am, you also had asked for a list of the persons that Captain DiGiovanni had provided. The names of the persons at the jail regarding the laptop protocol is Captain Giovanni, Donald Casey, who was here this morning, Stephanie DeJesus, Sonia Robinson, Courtney Battle, and Malik Muhammad.
Thank you for that. Would you be able to provide me with a hard copy?
I will put that in the order that'll be mailed to you, ma'am.
Wonderful, thank you.
Okay.
If I may, I don't know if I'm allowed to address the state directly.
Yeah, you're representing yourself, absolutely.
How do I go about getting a copy of my phone or utilizing my phone? Is that something that can be brought to the courtroom and during the evidentiary, the physical evidence, that I might be able to utilize that?
So my understanding is there was an imaging done on your phone with software called Cellrite, and that is part of the digital discovery that has been provided to you. If you are talking about the physical device being re-examined by your own expert, then you would need to find and retain your own expert to do that without giving you legal advice or suggesting that he is the person you hired. I know that defense attorneys in this area hire somebody named Richard Connor, C-O-N-N-O-R, and then that will be between you and the JAC and him, whether or not he wishes to work for you and at what rate, so on and so forth. And then that examination would be done by him with us being present.
Hi, JC. How you doing, guys? Another latecomer, but that's okay. It's good to see you.
Yes, I have reviewed, I believe, 2 or 3 different thumb drives were given to me at one point, where I researched all of them extensively, also included with Mr. Lane, and it is nothing of use. It's primarily cookies and history and so forth. So that's why I don't understand who it is, the legal expert that can give me a mirror download of my entire phone in regards to videos and pictures and contacts. I could probably supply a witness list sooner than later if I were to have accessibility to my phone in regards to my contacts. That's why I didn't know if it would be allowed to have my phone physically here in the presence of everyone, including law enforcement, to be able to physically look at my phone and go through it and to see what I can extract myself while here in the courtroom before trying to figure out how to locate and contact an expert to download all of that to receive.
So all that information should have been downloaded, and I'm not sure what has been provided to you, but we will be double checking that.
It has not been provided.
Yeah, your contact information, all the videos and photographs, everything on your phone should have been downloaded. And what you may have reviewed is just a PDF file called the timeline. There is additional data there, and we will make sure you have that. And then when it comes time to our digital evidence deadline, which I hope to exceed well before 9/3, we will be identifying which portions of it is of your phone, if any, that we seek to introduce at trial. So it may be texts from December 2nd, 2019, whatever it is. We will identify those pages, we will identify those files, because obviously your entire phone, however many gigabytes it is not going to just come into evidence. Like you said, there's so much of it would be not relevant.
Yes, thank you. So you all have already had access to my phone and have researched it fully?
We're not going to talk about our work product. I'm telling you what based on my experience from other phone examinations is, all that information should be there. And it's typically presented in two different fashions. One is a large PDF, typically hundreds or thousands of pages, depending on how much you use your phone every day. And then there's a separate big digital image file that is read with what's called a UFED reader. And then that is where you can go in and look at everything.
Yes, sir, thank you. I've not seen any of that.
We are going to make sure that that is taken care of.
And that,
What was
just
that
as
date?
clarification from the court perspective, is that something that would have been provided in discovery to prior counsels?
Yes.
Okay, then ma'am, as Ms. Cashman identified, she had everything. It's already been digitized for you. And to the extent you're able to have the hard copies, it'll be provided to you. So you'll have access to all that information today when you return to the jail.
Yes, thank you. None of it was,
Oh, Christina, I think I'd take my own life if I had to bunk with this person in a jail. I mean, bad enough being in jail. I'd rather be with a really violent, crazy man. You know, just this would be the worst person that you could lock me up with.
gone over in any way, shape, or form with Ms. Cashman or any prior. So this would be a milestone, an epic milestone for me to be able to finally do that. So now, if I don't have what I need or I'm looking for, how do I go about? I know you all can't tell me because of legal matters, but do I need to write a motion? I don't know what I need to do in order to finally get a copy mirror download of my phone. If it could be brought to you for physical, but the other physical.
So again, that is going to be something that requires an expert. And then if you get a defense expert and the JAC pays for it, then we make arrangements to meet with that expert. That expert will have the opportunity to image your entire phone just as we did, and you all can work with that image.
Yeah, Neverly, they're still going on. Maybe this is why the state is pushing for a plea deal, because they just don't want to listen to this. They just imagine having to do this in front of a jury. They're going to have to maintain decorum of court and procedure and do everything without screaming or just blowing their own heads off at the prosecution table. It's going to be nuts.
And you're going to be, if you don't already, on those thumb drives that Mr. Lane has, if you don't already have the full extraction.
Oh.
So again, that is going to be something that requires an expert. And then if you get a defense expert and the JAC pays for it, then we make arrangements to meet with that expert. That expert will have the opportunity to image your entire phone just as we did, and you all can work with that image. And you're going to be, if you don't already, on those thumb drives that Mr. Lane has, if you don't already have the full extraction and not just the PDF timeline of your phone, you're going to make sure that that is provided.
Okay, so that is not able to be included in the other physical evidence that you all are supplying.
No, what I'm saying is there's
Sarah and Wendy in a cell together. I think we've done it, guys. I think we've found the only way or method to resolve justice in this case. They need to be bunkmates. Okay. Oh, the ultimate life sentence. Just in confinement, away from all the other prisoners. Okay. They're fed through a letterbox in the door and they're in there together 24/7. That is a nice thought. You're right.
There's two different ways that I see phone extractions. One is the PDF, which is what I think you're referring to as the timeline of this communication, so on and so forth. And then there is the actual ginormous file that is read with a UFED program. And all that should be provided to you. Hopefully your laptop can use it. It does take some specifications on the computer to open it. In fact, we're addressing those issues at our office with our own computers. And if it doesn't work, we will cross those bridges as we get there. And I've worked with Mr. Lane before, just let him know.
Well, that doesn't fill me with confidence. If you can't even get the F reader or whatever it is to open the phone back up on your own computer, how do you expect it to work on this probably piece of shit computer that you've lent to her to use at the jail? You think she's not gonna be able to phone tech support and say, listen, I need you to come and put the drivers onto the computer? I can see at least postponements, continuance, maybe plural, with all of this going on. And I'm starting to really think that there's not going to be a trial, guys. We've been fooled. We've waited 5 years to see this. And I said from all the way from the beginning, I think there's a good chance she'll represent herself. That's happening. But basically, I can see it either being a plea deal or having another ridiculous round of delays. As hardline as this judge is trying to be, rules are rules, and if she can't view her discovery, that surely is cause for a continuance.
Mr. Lane knows how to find me. We will work this all out and get what you need.
Absolutely, yes. I am grateful for your information.
7th of October, that's 2 months today, guys, is due to start these proceedings.
Just to clarify, please, during the physical evidence of me viewing that here in the courtroom, am I not able to physically open my phone and search through it?
No, because
Okay.
it needs to be in a Faraday box.
Just a reminder to everyone joining the stream a little late, remember to leave a like on the video, guys. You know it helps us out. And if you help us out, you know, we just make better streams more often, more regularly, more streams.
Where radio signals don't come and go, because anytime you turn on your phone, it changes the contents of its phone, of the phone.
Thank you
You're
very
welcome.
much.
Ma'am, do you have any other questions?
Yeah, she's never going to say no that she doesn't have any questions. Until the judge cuts her off, she's always got a question.
Okay, so everyone is aware that I'm in the process of trying to talk to the captain. And handcuffs, okay. Your Honor,
Yes, ma'am.
I believe I am okay right now. You and I do not have a direct way of communication, and I didn't know. Another big hurdle is if the laptop has internet access where I don't know if emailing or messaging or whatever, however it is that you and I can communicate. Rather than snail mail, I'm writing a letter. I don't know when I write a letter, how soon you receive it, because sometimes it's days or weeks that it is uploaded to the clerk's website. Do you have a general time frame of when you actually know of something? Because you already had my address correction, but I don't believe updated.
It's been updated now.
No, I mean on the clerk's website.
I can't speak to what's on the clerk's website. I know for the purposes of my records and getting information to you, that clerical error has been remedied.
Do you have any other suggestions? If I do not have internet, would my only possibility to correspond with you be via mail?
That's my understanding. And you asked when I receive things. I get it as soon as I get it from in the mailbox. So we check the mailbox every day. As soon as I get it, it doesn't go to the clerk, it goes directly to me. And I review it. As you saw with the motions that you made reference to at our last hearing, that you had 5 of them, we set those for hearing immediately. And I intend on continuing to try to do that to facilitate prompt resolution to any concerns or issues or motions that you may have.
Thank you. And if I do have internet access or I'm able to put on, if it's not already, am I able to correspond with you via email?
You cannot correspond with me directly, but you can have conversations with my judicial assistant to the extent that you do have access to internet. I'll make sure to include her email address and telephone number in the order setting the deadlines that we addressed this morning.
Yes, thank you. And for any, I'm not sure specifically which JA, but as soon as something is scheduled, would you all please make sure that I'm included?
Hey, Maria, you're just in time for us to close, but good to see you anyway.
In the certificate of service or portal or whatever it is I might be attached to in order to receive notices to be populated here.
Notices have been set, ma'am. To the extent that there was a clerical issue, that's been remedied, but you have been copied on everything that's been filed with the court, including the JAC's response, the notice of the hearing that was set for today, and the notice of the filing of the protocol. With that, I will see you all this coming Friday at 8:45 to address the motion regarding reasonable freedom in movement. State anything else?
No, Your Honor.
All right. We'll see you all Friday. Thank you very much.
Thank you very much.
We'll return Ms. Boone to the custody of the Orange County Jail.
I'm grateful, thank you.
Yes, ma'am. Thank you.
Hey, KLK. Yep. It's 2:30 already here in Portugal, 2:30 a.m., but that's okay. We're closing it off for the night. Just right on the 3 hours mark, guys. Anyone not like the video yet? Go and like the video before we close. That'd be great. And remember, guys, there's a link to the Reddit post in the description for the video, a link to the Reddit post where everyone's talking about true crime metrics. So all you Reddit heads out there, go and check that out. If you want, there's already loads of people that aren't familiar to me. They're talking about the stream, they're talking about the channel, aren't they? They're saying, hey, this is a great channel. So it's really good for our exposure. If you want to go and add to it, that'd be even better, right? There's links to the social networks in our channel: Facebook, Twitter, Instagram, and Discord. And there's links to places you can support the channel: buymeacoffee.com, Patreon membership, YouTube memberships. Many thanks to all our brand new shiny members on YouTube. Yeah, they've been really rolling in. Glad you guys are all having fun with the memberships. And what else have we got to say? What are we doing tomorrow? Schedule, guys. Well, what are we doing tomorrow? I just wanted to cover this Sarah Boone case management hearing because it was just a couple of days ago. I saw it yesterday and I was a little late. It was on the 5th it took place. But what are we doing tomorrow? If anyone wants to leave a suggestion, hit us up on Discord or any of the socials. Email truecrimemetrics@gmail.com. I do see all those come in, guys. Thank you for your suggestions and the bits of information you send there. It's difficult to reply to everyone because there's so many emails coming in, but we really appreciate the love you're showing the Gmail and the Facebook, Instagram, Twitter, and Discord. And buymeacoffee.com. Like the video, super thanks, super likes, super stickers, super chat, super subscribe to the channel. And we will see you all real soon tomorrow at around 6:30 Eastern. Okay, you got that? Or you latecomers? I know it's still early for you guys, a lot of you in the States, especially on the West Coast. But what can you do, eh? What can you do? Maybe we'll have to start doing streams from 5 a.m. Portuguese time. I don't know. What time would it be then? Who knows? Anyway, great to see so many of you in the chat. Familiar faces, new faces, loving it. Stay communicated. Stay good. Be kind to each other. Don't be an Adelson. We'll see you tomorrow. Good night, guys.